Sir, I beg to mention item number 9.
Yes.
Your Lordship, we need 3 weeks time to file of the record.
Yeah, for the APDCL.
Yes, APDCL.
But 22 matter, why haven't you filed your affidavit?
We have
Till
received the instruction, but updated instructions are added. We have asked for that.
The learned counsel for the APDCL has prayed for time to file affidavit in opposition. Para, considering that this matter is pending since 2022, a last opportunity is granted to file such affidavit in opposition. List on 23rd of February.
Much of.
File it before that, otherwise, yes.
May I please, Lordship, I beg to mention item number 4, that matter has become infractious.
You are TSK.
Yes, my lord.
Sri T. Sikh, learned counsel for the petitioner, has submitted that by flux of time, the matter has become infructuous.
Right.
Also heard as standing counsel NRC.
Yes, my lord, NRC is there, problem.
Is it there in the court?
NRC.
Is it also heard?
A. Ali, my lord,
Yeah, is for the state election commission.
election commission.
Also heard. Is Mr. Ali there?
On behalf of AI.
You are there. Okay. Also heard Sri J. Payang, learned standing counsel NRC, and Sri. Your name?
I'm Islam.
M. Islam, learned counsel appearing on instruction of Sri A.I. Alif, standing counsel, EC, Election Commission of India, Para. Petition is accordingly dismissed as infructuous. Yes,
Item number 5 is also similar.
similar. Okay.
Similar, my lord.
Similar, infructuous.
They got the notice, but they are contesting the request.
My lord, I beg to mention item number 7, my lord.
Yes,
I have received instruction that the petitioner has got relief, my lord.
okay. Sri R. Sharma, learned counsel for the petitioner, has submitted it during the pendency of the writ petition, the grievances of the petitioner have been redressed. Full stop. Also heard. Transport Department. Anyone transport, madam? Also heard Miss Sri Bokolial, learned
7.
State Council, and Miss M.D. Bora, learned Standing Council, Transport Department. Para, matter is accordingly dismissed as infructuous. Yes.
Obliged.
Lordship, beg to mention item for listing your Lordship in motion stays
Motion is when?
next Monday, your Lordship.
Have you filed or not?
We file your Lordship. Right.
Yes.
Please, your lordship, similar, your lordship listing of a motion matter.
When? Monday?
Yes, lordship. Much obliged.
Please, your lordship, I beg to mention writ petition for listing in
Or
orders.
motion?
Orders.
Orders, what are the urgency?
Lordship, on 26/11, the writ petition was last listed. It is a matter for freezing of bank account. On the last date, the honorable court had put certain conditions on the petitioner and allowed to run the bank account, but the bank authorities are not cooperating with the said order.
You file an IA, we'll consider your IA.
Already 4 weeks has,
You file an IA, these are subsequent developments, bring it to the court's notice. We'll consider, file an IA.
Obliged.
May it pleases your lordship. Lordship, I beg to mention item number 10. We have the concern of the opposite other party as well.
Yeah, for the Corporation Department. Okay, on a request made on behalf of the Corporation Department, matter is adjourned to be listed on when? 16th of February.
Okay, lordship.
Have you filed your affidavit? You have?
Everything is done. The matter may be fixed for final disposal.
For 16th February for admission hearing.
My lord, only after 2 weeks,
16th
16.
February? If you suggest any other date, tell us. We'll consider. 16th is a Monday. We'll have it. Or if you want before that, you can have it on 11th. 11th February. When? 16. Okay, 16 February.
May
Yes.
it please, Lordship?
Yes.
Like to mention for listing of a repetition for orders, Lordship.
Orders, what orders? What is the urgency?
Lordship, on the last occasion, this honorable court allowed us to file a amended writ petition, and already we have filed. And the matter is relating to non-issuance of the insurance policy. And later we came to know that the amount of money already been released to the another person, Lordship.
You have filed amended writ petition.
Yes, Lord.
When did you file?
Yes, Lordship, we have filed on last week, Lordship.
Okay, we'll have it on Wednesday next.
Okay. May it please, your Lordship. My lord, item number 30, my lord.
Hmm.
I'm mentioning with the consent of the other side, Lordship.
Hmm.
Can it be taken, Lordship, from some other date, Lordship?
13,
30, my lord.
30,
30, Lordship.
supply list.
Supplementary.
When do you want?
Lordship will fix a date, my lord. After Lordship.
You have taken the consent.
Lordship.
You are for the petitioner.
Lordship, my lord.
On a request made on behalf of the petitioner, matter is adjourned to be listed on 12th of
Lordship.
February.
Lordship, can it be on, my lord, 27th, my lord?
Matter which year? Okay,
24, my lord.
on, no, not 27, 26th.
26, Lordship, I have one.
27 will be difficult because if you are one for admission here, okay, we have it 27 too. 27 too.
My lord, all right. Thank you, Lordship.
May I please, your Lordship. A bench mention for listing of a writ petition 5872 of 2025.
For,
For orders, your Lordship.
what is the
Actually, it is
urgency?
in the admission stage now. Arrear of rent, your Lordship.
It's not urgent. Or it may be urgent, but not a matter for out of turn listing. You approach the registry.
Okay. Deeply obliged, your Lordship.
Yes.
The petitioner before your lordship, petition number 3221, they are the shopkeeper in the, doing their business, in the campus of the petitioner fishery, and they have been running their shops, since 2001. And that too, with the due permission of the authority,
Which authority?
the Assam, Fishery Development Corporation,
Where is the authority? Let us
Yes,
see.
your lordship will find at page number 63,
How many petition? 21 petitioners.
there are 21 petitioner.
Yes.
Petitioner number 1 is the petitioner fishery, 2 is the settlement holder, and 3 to 21 is the private petitioners.
Okay.
So, say page number 63 and Annexure 3, that is the
Now, what is your grievance?
grievance is that, in the meantime, we are served with a petition for eviction,
Petition notice for eviction.
So that your lordship will find at page number 75.
Yes. What is your, what right do you have to continue? What right do you have to continue?
Because there are other petitioners also, but they have not been served with the, they are doing their business in the same campus.
There are other petitioners or other parties.
Other, other shopkeepers are also.
Shopkeepers, you don't say petitioners.
My lord, I'm sorry, the other parties are there. They are
So
also.
even, can that be a ground, negative equality?
Even
Maybe in
then,
initial phase, you are being thought to be evicted, thereafter the others.
no, because we are doing the business there with the due permission of the authority, Your lordship will find at page number, annexure 3, that is page number 63. They permitted us,
63.
Yes, They permitted us, May I read,
Yes, please.
Inviting your attention to the above noted matter, you are hereby informed that Iman Ali, as per the letter referred to above, the president of Satishala Fishery Market and Fishery Center Committee was authorized to manage the market for the period of 2017-18, 2018-19, 2019 and 20. Although the market managing committee was permitted to raise temporary house in the market campus, while letter referred to above, the same did not happen yet as the site was not handed over to them. On the other hand, it came to our notice from the written complaint of the president of the committee that the block development officer of the area has again auctioned the fish selling center secretly with complete disregard to the guidelines of the corporation.
Yes.
Therefore, your request to. Then, the next
Where is the authority? This is not the authority.
This is the Assam Fishery Public.
So where is the authority to install, to have shops?
This is the letter written by the
No, where is the contents? Please read the contents by which you a right of any nature has accrued to you.
Yes, then the next annexure, page number 60.
Page 60?
66,
66. Yes, please
Yes,
read.
With regard, this is also written by the same authority,
Yes.
Then it was written to the circle officer,
Yes.
Then subject is with regard to the construction of temporary one roof house
Yes.
at Satishala Fish Selling Center. So,
Yes.
sir, the date for constructing of temporary one roof house at Satishala Fish Selling Center has been fixed at 11 AM of 14/11/2019. Therefore, you are requested to be present there and also to make arrangements so that no illegal encroachers can create any nuisance.
Yes.
So this is the,
So where is the first letter by which you have been given a permission to have a shop?
Because, my lord,
Which letter?
the earlier, my lord, communication also shows that it was permitted.
Where? Where is the permission?
That permission letter is not with.
So if letter is not there, some documents by which, from where you can gather that you are permitted to have your business.
But that may not be, Assam Fishery Development Corporation is saying that.
So,
they are
right, Mr.
permitted.
Ali,
My
you have to show some kind of a right to continue.
My lord, even the marketing committee, my lord, they also filed one petition that your lordship will find at page
You
number
don't have a
21.
matter, you don't.
It also transferred that we are running the business, my lord, since 2001, my lord.
On the strength of which document?
That permission, then I have, my lord, that
There
is
is
not.
no document, nothing, no materials to show that any right was created in your favor.
But my perception is that, my lord, see the earlier two
We'll issue
letters,
notice, at best we'll issue notice.
my lord, I will produce that, my lord, on the next date fixed, my lord. But in the meantime, my lord, because we have been asked to vacate by, today is the last day, my lord. If we are not getting any interim protection, then maybe that, my lord.
To get an interim protection, you have to
My-
make out a prima facie case. You make out a case.
My-
Where is your prima facie case? There is no document
I'll
that
produce it.
gave you some kind of a right to.
My- But at
Heard.
least, my lord,
Sri A. Ali Learned Counsel for the petitioners who are aggrieved by a notice. What is the date?
my lord, 26th,
By notice dated 26/12/2025,
my lord.
whereby the petitioners, petitioner numbers 3 to 20.
21,
been-
my lord.
Hmm?
3 to 21, my lord.
You have written 3 to 20 in your synopsis. 3 to 21
Wait, 20, I'm sorry, my lord.
have been directed to vacate the land of Sarkari Dag number 1 situated at Revenue Village Satisala under Moja Goroimari in the district of Kamrup. Full stop. The aforesaid land is reserved for 34 numbers Satisala Fishery Market Kamrup. Full stop. The Learned Counsel has submitted that since the year 2001, the aforesaid petitioner numbers 3 to 21 are running their shops.
Right.
Full stop. Para. Let notice be issued. Returnable on 18th of February 2026. Yes, will be accepted notice.
I'm looking for 529, my lord.
Fishery Department. Fishery Department has Mr. Sharma is there.
Yes.
Is he there in the court?
I think.
No? Any of his colleague?
S. Sutia, my lord. S. Sutia is also done.
Hmm.
I think. Yes,
Oh.
so the S. Sutia is.
Is she there? Is she there in the court?
court.
Miss S. Chutia, Learned Counsel, accept notice on behalf of the Fishery Department, namely as per numbers 1, 2, 3, 4,
4, my lord.
5.
Yes.
M. Chetia, State Counsel for 6,
6,
7, 8, and 9. Extra copies be served upon the Learned Counsel for the respondents. Para. Madam, you are recording your name. AFDC also you will be taking? No.
Yes, this is coming.
3. Ali, the Learned Counsel, prays for an interim order. Full stop. However, this court, however, on a specific query, comma, no right of any nature has been able to be demonstrated by which the petitioner were permitted to run their business. Full stop. In any event, comma, the eviction notice appears to be issued in the interest of public service. Para. In that view of the matter, comma, the prayer for interim order is declined.
Obliged.
That big, your lordship. The affidavit has been filed, your lordship. And it's number 22.
Yes, yes, madam.
The timing, lordship.
Timing, what timing? 17 matter. Lot of time has already gone. No further timing.
Some problem. Then.
Hmm?
In timing, I have also some problem. I have some other matter, code number
Yes,
1.
what is the matter? Please the matter.
Non-payment of bill, lordship.
There is admission.
Lordship. This is
Where is the acknowledgement in writing by the head of the department?
the chief engineer, water resource, Assam already filed the affidavit, lordship.
In the affidavit, is there any admission, madam? Decca?
Lordship, admission, lordship, only 3,000 to 723 is left, your lordship. Other payment already made,
That
your
matter has been substantially redressed. What is there to be decided?
We are claiming a 4,96,241, lord.
4 lakh?
4,96,241,
4,96,241.
lordship.
And how much has been paid?
As per this bill, lordship, we are not paying, but as per the affidavit in opposition, lordship,
Yes.
the bill value is 1,37,529 and payment made 1,33,806 rupees. And outstanding liabilities 3,723.
Yes.
Because the contradictory is there.
Now you have to approach the civil court then. If it is,
Chief, adjourn
why not adjourning? So these are matters of
senior will pay because
that will not have any effect on the orders we are going to pass. Who is the senior?
Mr. A.M. Bhavya.
We will record his name. Is he there in the court?
No, lordship, she is fighting, she is packed his vehicle, lordship, that's why you.
Not make any difference. See, we cannot go beyond what has been acknowledged. And here, fortunately, in your favor, there is an affidavit where certain admissions have been made. And only some amount is remaining. For the rest of the amount where it is disputed, you have the liberty to approach the civil court if it is permitted by law. That is the order we can pass.
Just one day, lordship. or
No,
two
not
days.
one day.
Next
17
day,
matter.
lordship,
Don't make this kind of prayer. 17 matter. Let him come. We'll wait for a while.
lordship.
Ask him to come. We'll take it up at after 10 minutes.
Alright.
I think you. Yes.
This is for payment of vendor's bill under PNID department, your lordship. They have disputed, filed the affidavit and disputed the matter, your lordship. So allowed to go to civil.
You go to the civil court. How much is the amount?
Lordship, there are two petitioners. So far as petition number 2 is concerned, they have paid already. For 1 year, lordship, it is.
One for two, the grievance has been addressed.
Yes, lordship.
Okay. What is your name? R.A. Chaudhary?
Yes, lordship.
Hearts Free R.A. Chaudhary, learned counsel for the petitioners. Also heard Free S. Datta, learned standing counsel PNRD, as well as Sri Bukulia, learned state counsel for the official respondents. Para. The instant writ petition has been instituted by the petitioners, who are 2 in numbers, for release of contractual dues. Full stop. The petitioner number 1 claims to have supplied certain materials for which a bill of rupees 5,26,600 was raised. Similarly, a similar claim has been made by the petition number 2 for supply of materials for which bill of rupees 15,80,942 was raised. As the bills have not been cleared, the instant writ petition has been filed. Para. At the outset, Sri Chaudhary, the learned counsel, has informed that so far as the grievance of the petition number 2 is concerned, the same has been redressed, and the existing grievance is only for the claim qua the petition number 1. Para. Sri Datta, the learned standing counsel, by drawing the attention of this court, standing on PNRD, by drawing the attention of this court to the affidavit in opposition filed by the respondent number 2 on 5/6/2024, has, however, submitted that the claim is disputed. Full stop. For ready reference, the relevant averments made in paragraph 5 of the affidavit in opposition are extracted herein below. Full stop. There is a clear averment that there is no record of 5 and 6, 5 and 7. There is no record of any supplies made or any pending bills. Para. In view of this court, the Honorable Full Bench in the case of Tamsir Ali versus so-and-so has laid down certain guidelines where a claim for release of contractual dues can be entertained by a writ court, and the following principles have been laid down. Principles. In the instant case, apart from the fact that there is no acknowledgement in writing by the head of the department of chief engineer, the claim has been disputed.
Instead of chief engineer, my lord, it's commissioner.
No, the head of the department, we have
Well,
said,
yeah.
oblique chief engineer, disputed on affidavit, full stop, in view of the above, no relief whatsoever can be granted to the petitioner, full stop. The petitioner is, however, accordingly, the petition stands dismissed. Liberty is, however, given to the petitioner to approach the civil court if permitted by law.
So only one observation, Lordship, the period, the limitation.
That is what we have said, permitted by law.
Hello.
Yes, one.
Madly done. One of the Udyar Malad affidavit, Malad. Matter may be disposed of, Malad.
Yes, that is what we are trying to do.
Yes, Malad. And only liberty may be given if she has any grievance, she may approach.
That is what we are trying to do. Heard. Sri A. M. Barbuya, learned counsel for the petitioner. Also heard Ms. R. Deka, learned standing counsel, Water Resource Department, which has also filed affidavit in opposition on 5/4/2025. Para. Considering the facts and circumstances, and also the aspect that this writ petition is pending since the year 2017, the same is taken up for disposal at the admission stage. Please have your seat. The writ petition has been instituted for a direction for payment of outstanding bills for work orders dated 28 to 2002, 16 to 2002, 19 to 2002, and 5 to 2002. Full stop. It is projected that the petitioner was allotted the aforesaid works for construction of protection of the Katlichara Bazar from the erosion of river Katakhal, for which a bill was raised. Full stop. However, the same not being released, the instant writ petition was instituted. Full stop. Para. It, however, appears, Miss Deka, the learned standing counsel, has, however, submitted that there is no communication enclosed regarding acknowledgement of the liability. She has, however, submitted that the claim, that the admissible amount has already been released, and how much amount is pending?
723.
23, is now pending, Your Lordship.
And only an amount of rupees 3,723 is the balance which is to be released to the petitioner. Para. The scope of a writ petition to entertain an application, entertain and adjudicate an application praying for release of contractual dues is limited, and the guidelines have been laid down by the Honorable Full Bench in the case of Kamsar Ali versus so-and-so, in which the following principles have been laid. Quote करेंगे, well. In the above, in the facts and circumstances, in the present case, it transpires that the amount entitled to a petitioner has already been claimed to be released to him, and there is only a balance of rupees 3723 to be paid. Full stop. Para. In view of the above, while this court directs the release of the aforesaid balance amount of rupees 3723 to the petitioner in terms of the guidelines of the Honorable Full Bench, the petitioner would be at liberty to approach the appropriate civil court for making any further claims if permissible in law. Full stop. Writ petition stands disposed of.
Diploma.
Yes, madam.
Lordship, we are challenging two impugn orders, Your Lordship. My lord may kindly refer to Annexure 15, which is at page 107. Sure.
107.
Yes, Lordship.
Just give us a minute, 1 minute. Just give us a minute. Madam, your annexure goes to 6 pages, 7 pages. Is for the railways? Madam, you are for the railways?
Yes, Lordship. Lordship, as per our condition, there.
No, we have not heard, but we are going for a disposal of this matter. Ready for the matter?
Lordship, kindly fix on another date, Lordship.
These are old matters.
Yes, Lordship, I will have to, what is the latest position of this matter? Don't have any instruction, Lordship.
That would not matter, the adjudication of this case. We cannot afford to adjourn a matter of 2018.
Lordship, then fix it then tomorrow, Lordship.
Tomorrow.
Or Monday, Lordship.
Last occasion we have made it very clear. Admission hearing on 29/1. You should have been prepared.
Yes, Lordship.
We are not going to adjourn matters of this nature. 2018 matter. What is your claim, madam?
My claim is, Your Lordship, that the bank guarantee has been expired on 31/3/2018 itself.
Okay.
And we are challenging the bank guarantee as well as the cancelling of the purchase order, Your Lordship, which is dated 4/3/2016.
Cancellation of the purchase order.
Yes,
So,
Lordship.
is there any live cause of action? Will you get anything now? What was the order? What was the quantity involved, goods involved? What was the purchase order? Regarding what?
Purchase order was regarding, Your Lordship, it was an e-tender for supply of railway signaling cables, Your Lordship.
Cables.
Yes, Lordship.
So even if we suppose you are successful in convincing the court, we set aside, but these works have been done. Now, what do? We can grant you liberty to approach the civil court for damages at best. If we direct your second prayer at page 16 for consideration of the representation, that perhaps will not give you anything. First prayer is quashing the letters of cancellation. Effectively, you are not going to get anything. We'll have it after some time. both of you just go by the records and assist the court. There may not be anything, we can at best give you an liberty to approach the civil court for damage. If you can make out a case.
Yes, you can make it.
Okay. Third, Ms. K. Sharma,
Yes, sir.
learned counsel for the petitioner. Also heard Ms.
Ji, sir, no.
G. Sharma,
Yes, sir.
learned counsel appearing for the railways.
Yes, sir.
Para. The instant writ petition has been filed. Please have your seat. With the following relief, page 15. Huh? What for it? Yeah? The grievance of the petitioner is against the cancellation of the purchase order, which relates to supply of cables. Full stop. So far as the first relief prayed for is concerned, is for quashing, is for interfering with such orders of cancellation. And the second prayer is for consideration of the representation of the petitioners dated, petitioner dated name. The representations are, however, of the year 2017. Para. This court is, after hearing the learned counsel for the parties and on agreement, this court is of the opinion that no effective relief can be granted to the petitioner, even if a case of interference is made out qua the orders of cancellation of the purchase order. Full stop. The petitioner, if successful in making out a case that such orders were not supported by law, can claim damages in the appropriate court if so advised. Full stop. Para. In view of the above, more particularly because of the flux of a long period of time, which a long period of time of almost 17, 18 of 8 years, of more than 7 years, this court is of the opinion that the writ petition is liable to be closed. However, with with a liberty to the petitioner to approach the appropriate civil court for redressal of his grievance, including a claim for compensation if permitted by law. Compensation, claim for damage. Yes, madam.
May I please, your lordship?
Yes.
Lordship, I have not got any instruction from the petitioner along that pending case, lordship. We give a 1 week time.
We're closing this. Is there any acknowledgement?
No, Lordship.
Huh?
No, Lordship. Even Lordship, they were supposed to furnish, petitioner was supposed to furnish extra copies to me, Lordship.
No, is there any acknowledgement? We are on those, we are not seeing.
No, Lordship, I have not received any instruction, Lordship, but.
No, madam, is there any acknowledgement in writing by the chief engineer or the head of the department? Then you will pass the same order.
No.
What is your name, madam?
Miss S. Das on behalf of Argosan.
Heard Miss S. Das, learned counsel appearing on instruction of Sri R. Goswami, learned counsel for the petitioner. Also heard Sri Upamanyu, D. Upamanyu, learned standing counsel, health department. Para. This writ petition. No, I'm considering the subject matter involved, and more particularly the fact that this writ petition is pending since the year 2019, the same is taken up for disposal at the admission stage. Full stop. Para. As per the facts projected, the petitioner is a contractor and supplier and had made certain supplies to the Tezpur Medical College during the year 2015-16 pursuant to a letter of acceptance dated 11/5/2016. Full stop. The petitioner claims to have been paid an amount of rupees 16,54,843. Full stop. However, the remaining balance amount of rupees 32,36,070 was not cleared, for which the instant writ petition was instituted. Full stop. Ms. Das, you said? Ms. What?
Miss S. Das.
Ms. Das, the learned counsel, has drawn the attention of this court to certain documents relating to the handing over and taking over certificates, and also certain legal notices issued on behalf of the petitioner making the demand. Full stop. She has also drawn the attention of this court to a communication dated 13 May 2018, whereby detailed report was sought for. Para. On the other hand, Sri Upamanyu, the learned counsel for the health department, has submitted that to maintain a writ petition for release of contractual dues, there has to be an acknowledgement of the liability by the head of the department / chief engineers, which is not there in the present case. Para. Then answer only. Then civil court. Okay. Hello. Okay. Yes.
Also, may kindly produce order dated 35/2018.
Yes, we have seen that. Yes, up-to-date instructions, Mr. Datta.
My lord, I have received this instruction, my lord. On 9/6/2025, this letter was sent to government, my lord. My lord, we have received the validated vouchers from the district commissioners, my lord. Now pending for financial sanctions, my lord. Thereafter, what happened, my lord? I have to take instruction from the government, my lord.
Okay, we grant some more time. Okay.
Come down.
You are UK Deca.
Lord.
Heard Sri UK Deca learned counsel for the petitioner, who has referred to the order dated 35/2025. Put the para. Sri S. Datta, learned standing counsel PNRD, has submitted that pursuant to the aforesaid directions, instructions were issued to him way back on 9/6/2025, as per which certain developments were made towards settlement of the dispute. Para. He, however, prays for some more time to get the updated instructions. Para. In view of the above, matter is adjourned to be listed on 16th of February to enable the learned standing counsel to obtain the updated instructions.
Hello.
Oh, pleasure.
I know.
11.
So Lordship, this is regarding the non-payment of dues, non-payment of dues.
Mr. Chaudhary, would you like to appear in this matter? If you appear, we'll allow you to make the submissions. Madam, you need a senior in this matter. You don't need a super senior, you need a normal senior. Okay. Yes, what is it?
This is non-payment of dues.
Non-payment of dues?
Yes.
Where is the acknowledgement in writing? Is there any acknowledgement?
It's a good. Yes,
Page?
in page number 17, an extra C.
This is the completion certificate. Where is the acknowledgement in writing? There has to be an acknowledgement in writing. And by whom?
By
Who
the
has to make the acknowledgement?
Chief engineer.
Chief engineer. Yes, you know about it. So where is the acknowledgement by the chief engineer? See, madam, this is a writ proceeding. You may have a case, but unless and until you follow Tamser Ali's requirement, will not be in a position to grant you the relief. Yes, Mr. Gogoi,
There's no admission from the head of department, Lordship.
you approach the civil court. Yes, Madam Chaudhary. No acknowledgement.
Sorry,
Tamser Ali is not being followed.
Lordship had already passed an order day before.
Yes,
But if I may say something,
yes.
in other similar cases,
You cannot say something which is beyond Tamser Ali. Similar cases are not Tamser. Tamser Ali is by a full bench.
yes,
We have to follow full bench.
yes, Lordship. No, in those cases, similar.
Those cases we are not following.
No, similarly situated, but I.
Well, whatever, we cannot ignore Tamser Ali. It's a full bench.
That is there.
If somebody is not following full bench, we cannot help.
Then Lordship. can-
We have to maintain some discipline. It's a full bench. And exactly on this point.
What had happened there was that a verification exercise was done. And. from
See,
that
in
veri-
some cases, on an affidavit, they acknowledge.
Yes, Lord.
Matter becomes easy for us. It's better than an acknowledgement in writing by the chief engineer. But that is not the case in your, in hand. We'll give you liberty to approach the civil court. Okay. Heard, Ms. B. Chaudhary, learned counsel for the petitioner. Also heard Sri R. Gogoi, learned standing counsel. PHE.
PHE, first one, 1,
PHE.
2, 3, and 4. And
Also,
5.
considering the facts and circumstances, comma, the instant petition is taken up for disposal at the admission stage. Please have your seat. The petitioner has approached this court for release of contractual dues for certain works claimed to have been done by him in the year 2014-15 under the Hojai PHE division in the district of Hojai. Full stop. It is submitted that the work was completed in all respects, and in this connection, the learned counsel, Ms. Chaudhary, the learned counsel has drawn the attention of this court to the physical progress report, to the completion certificate, as well as the physical progress report. Full stop. The learned counsel has also drawn the attention of this court to a representation submitted on 14/11/2023. Para. On the other hand, comma, Sri Gogoi, the learned standing counsel has submitted that to maintain a writ petition with a claim for release of contractual dues, comma, there has to be an acknowledgement in writing by the head of the department / chief engineer as laid down by the Honorable Full Bench in the case of Tamser Ali versus so-and-so. He has submitted that apart, comma, the writ petition has been instituted in the year 2024 of a work which was completed in the year 15-16. The Honorable Full Bench in the case of Tamser Ali versus so-and-so has laid down the following guidelines. Full stop. Para. In the instant case, comma, there is no such acknowledgement in writing of the liability by the head of the department / chief engineer. Full stop. In that view of the matter, comma, this court is of the view that no relief can be granted in this proceeding to the petitioner. Full stop. The petition is accordingly dismissed. Full stop. However, liberty is granted to the petitioner to approach the civil court for making the claim if permitted by law.
Much obliged.
All right. Yes, next. Yes, Mr. Gogoi. Gogoi on this side, what is wrong? Huh?
my lord, I am a bidder of a petrol depot, my lord, under the
You have
HPCL.
shifted your loyalty.
No, that's trying to balance right and left.
Right and left, okay.
Balance.
What is it?
My lord, our application for allotment of a
Petrol pump.
proposed petrol pump was rejected, my lord.
Okay.
The last page one. It
What
is in page
you are for
133.
the, which HPCL?
1 and 2.
Well,
HPCL?
they have, yes, ma'am. Well, they have filed their affidavits. We'd like to file a short reply and fix it for hearing, madam.
We have seen the affidavit. What is there to?
I'll take some instruction because this person is also in a touch, like after the interim order, I will
What kind of interim order?
Subject to outcome.
subject
Huh?
outcome.
Subject, that's not an interim order.
Well, just can it be listed next week, but for hearing, madam? I know what is the fate coming to.
So
be-
why are you stopping the inevitable? Let it happen today.
For the satisfaction of the client, madam, just want to file just one reply.
Will it make any impact on the decision making process?
Judicially, no, madam.
Let us decide it today.
In
Why
that
should
case,
the-
lordship will
Huh?
listen. That will waste of time also.
Okay, yes. Facts in minimal. Yes, what is it?
Well, I have participated, my lord, in a tender, my lord, floated by the HPCL for allotment of, my lords, retail outlets, my lord, in Hujai, my lord, in the district of Hujai.
Hmm. Then?
And then, my lords, it got rejected. It got rejected on that ground, my lord, and if you find the impugn order,
Page
133.
133. What is the present stage, Mr. Thakur?
LOA has been issued to the private respondent, madam.
Yeah, for the private respondent. 133. What are the grounds of rejection?
And the plot of land which I had offered, my lords, they are it's a joint patta, my lords,
More than one owner.
more than owner.
You could not give a separate document
No,
to show
yes,
that you are the exclusive owner.
My lord. I could provide only two, my lords. The petitioners, my lord,
Page 124 is the government requirement.
Out of 12, only 2 has executed a lease.
See, you can either be the absolute owner or you can be the leaseholder. You could have taken on lease from the other co-owners.
My lord, I tried to. What has happened, my lord? The other person, the person whom I entered into an agreement, my lord, he had promised me that he'll be doing the needful, so I entered into that, my lord.
Okay, recently I have decided a case of this nature. Hmm? Very recently, I think last week. Similar. I think BTC.
Yes, that was a bit different, my lord, because that was some non-tribal person had taken the right to the land by
No, but
inheritance.
he was not the absolute owner.
Yes.
Okay. We'll pass a very small order, okay?
Well,
Heard Sri D. Gogoi, Learned Counsel for the petitioner. Also heard Sri L. Bhattakur, Learned Counsel for the
Respondent 1 and 2.
respondents.
No, 1 and 2 minutes. He is for 3 minutes.
1 and 2.
Yes, ma'am.
1 and 2, where as well as Sri. What is your name?
Mr. MR.
M.R. Islam. For the respondent number 3. Para. The grievance of the petitioner is an order dated 26/7/2024, whereby his candidature for grant of a retail outlet has been rejected. Full stop. As per the facts projected, the petitioner, who is an ex-serviceman of the Indian Army, had participated in an allotment process which was advertised on 28/6/2024. Full stop. The petitioner claims to have entered into a lease agreement with two persons who are co-pattadars of the plot of land. Full stop. However, the impugned order has been passed on 26/7/2024, rejecting the candidature as the petitioner could not fulfill the requirement of being the absolute owner of the land required for construction of the retail outlet or the leaseholder. Full stop, para. Three, Gogoi, the learned counsel for the petitioner has submitted that the order was issued without giving adequate opportunity. Full stop. The learned counsel has, however, fairly submitted that though there was an understanding with the co-partners for giving the plot of land on lease to the petitioner, the formalities could not be completed. Full stop, para. Three, Bothakot, the learned counsel for the corporation has submitted that the cancellation order has been passed on relevant and germane considerations. Full stop. He has submitted that the requirement of having the land as the sole owner or the leaseholder is a mandatory requirement which the petitioner could not fulfill. Para. The scope of a writ court to exercise its powers under certiorari jurisdiction is only to examine the decision-making process. Full stop. In the instant case, the impugned order clearly states the reason for which the candidature of the petitioner has been rejected. Full stop. As indicated above, the reason cited is with regard to non-fulfillment of the requirement to have a land on his own or being the leaseholder. Full stop. The aforesaid consideration cannot be said to be extraneous or irrelevant. Full stop. Para. In view of the above, this court is of the opinion that no case for interference is made out, and accordingly, the writ petition is dismissed. Yes. Interim order is any sense vacated. Yes, Mr. Chakraborty.
Your Lordship, I am for your Lordship applicant in the IA, your Lordship. Mr. Ken Chaudhary is supposed to appear, your Lordship.
IA for what? IA for?
For vacation and modification of the interim order, your Lordship.
You're for the applicant?
Yes, your Lordship. He's on leg, you'll be coming, your Lordship.
You have filed your objection?
I filed my own.
When do you want? Today?
Today, you'll after sometime, your Lord.
What is the interim order?
My lord, the letter of intent has been stated, which was.
Letter of intent?
Yes, which was issued in favor of respondent number 6 by the IOCL authorities in regard to the retail outlet.
Okay.
There's.
What are your grounds of challenge?
Well, three grounds. One is basically, this was for OBC category. The OBC certificate, which was produced by respondent number 6, that was of prior year, of earlier year, but it had to be subsequent to the date of advertisement. So that is the first defect. It is there in the interim, the order that was passed, it is reflected out there. That is the first ground. Second ground, my lord, is so far the.
How does the category changes? If one is an OBC, he remains an OBC.
That is one of the defects, my lord. The second being the categorization of the candidature of respondent number 6 in group 1 on the strength of a lease deed which was enclosed with the application form and thereafter which was scrutinized. That is defective in view of the fact that it is a lease deed for a land value of 60,000 per year, amounting to a value of 12 lakhs for 20 years. It's a lease deed of 20 years. The stamp duty that has been remitted is 3,700 odd, whereas it ought to have been 1,20,000. The very fact that the lease deed being defective, the categorization of respondent number 6 as group 1 candidate, that suffers. That is erroneous. And the third and the most vital fact is there is a requirement as per the brochure that the candidate has to furnish an appendix 7A issued by the concerned district administrator
Administration Authority, District Commissioner to be precise. Now, in terms of which it would be certified that he is a person belonging to OBC and non-creamy category. Now, he furnished the 7A on 21/12/2023, which I have annexed, and subsequently on being required by the IOCL authorities to furnish it on or before the date of application, he furnished another 7A, Appendix 7A, dated 6/9/2023 to suit his case, to suit his entitlement. Now, this 6/9/2023, by making RTI applications, we received reply from the district administration that the 6/9/2023 certificate was never issued by the Deputy Commissioner. Now, this amounts to, as per our humble contention, Violet, of an act of fraud, and fraud vitiates any solemnized act or any solemn act as per our contention, for which we are before this honorable court. These three grounds have been taken into consideration by this honorable court in passing the interim order.
Okay. Yes, what do you say?
Your Lordship, all the three grounds have been taken care of in my IA, Your Lordship, as well in the affidavit in opposition.
Okay, we'll wait for a while.
Your Lordship.
Yes.
Well, this is regarding settlement of ghat by the Gaon Panchayat. Well, how it happened in this case, Malad? Three bidders were found
Three bidders were there.
there. And respondent number 7 and I put the same bid. Well, as per clause 14 of the advertisement, it has to be settled by holding a lottery.
You petitioner and R7.
Petitioner and R7.
Same bids.
Same value.
Same value.
My lord.
So draw of lots.
Draw of lots. But it was not done. It was the secretary whose services was already withdrawn by the Jila Parishad. He sent it to the BDT Anchalik Panchayat for deciding. Then BDO, the Jila Parishad asked the BDO to send the file to Anchalik Panchayat, and Anchalik Panchayat selected him as per R7. Against that, I am before your lordship. Now, my lord, the respondent number 7.
What is the status now? Who is R7? Mr. Khan.
R7.
So why didn't you hold a draw of lots?
My lord, we have already filed affidavit, my lord. Lordship, may kindly have my affidavit page number.
No,
1.
it's what Mr. Day is contending, that if two values are same, you have to
But his bid was defective, my lord.
defective bid.
Yes. We have categorically stated in our affidavit, my lord.
His bid is also defective, my lord. My lord, kindly see then clause 36 of the advertisement.
Both bids are defective.
His bid is also defective.
What about yours?
My lord, they say it is defective.
How his bid is defective?
Defective, my lord, as per clause 36, my lord, the bidder has to, it should be a registered owner of boat. But he has produced the certificate of hired boat. He has hired from somebody, my lord. And that too, it is not now plying in the ghat, and it has already been sold out. Enquiry has been done by the IWT department.
Who is running the show, Mr. Datta?
My lord.
Who is running the show?
My lord, we have one, my lord, inspection was also done, my lord. As per inspection, he is running a boat with a valid registration, but hired. And hiring a boat is not, my lord, anything bar, my lord.
No, he says that clause 36 requires to be a registered owner.
Registered boat.
Registered owner.
He is not the owner.
Madam IWT, you have a role. Yes, Madam, Mr. Datta, your friend has a role or not?
She can assist, my lord.
He is not a party.
Not a party, but she can assist, my lord.
Where is that clause, Mr. Day?
My lord.
Where is that clause? 36?
36 at page 29, my lord.
29.
My lord.
29, yes, 36. Only those bidders who have valid registration and have adopted mandatory suitable shall be allowed to participate in the bid. Must compulsory furnish. Who has valid registration means?
Bidder, my lord. Bidder must have valid registration.
Registration regarding what?
Both.
No, where is it required? Where are the wordings? Please read.
Only those bidders, my lord, bidders
Yes.
who have valid registration and have adopted mandatory safety measures in the operation of boats, ferries, shall be allowed to participate in the bidding process.
Let us read the vernacular.
Yes,
Vernacular, page.
page 36. বৈধ পঞ্জীয়ন থকা আৰু নাও ফেৰীৰ চলাচলৰ ক্ষেত্ৰত বাধ্যতামূলক সুৰক্ষা ব্যৱস্থা গ্ৰহণ কৰা নিবিদাকাৰী. It's not saying that he himself is the owner, my lord.
bidders.
Bidder has to be the owner.
Nibidakari.
My lord, may I read again, my lord? বৈধ পঞ্জীয়ন থকা আৰু নাও ফেৰীৰ চলাচলৰ ক্ষেত্ৰত বাধ্যতামূলক সুৰক্ষা ব্যৱস্থা গ্ৰহণ কৰা নিবিদাকাৰী সকলকে ফেৰী ঘাট নিবিদা প্ৰক্ৰিয়াত অংশগ্ৰহণ কৰিব পাৰিব.
We participated, he should.
His interpretation may not be wrong. His interpretation may not be wrong. It cannot be said to be an interpretation which does not require any consideration. He may be right.
Let us speak, my lords.
Mr. Khan, on facts you cannot dispute. You are not the owner.
I'm not the owner.
Whether a hired boat can be is permissible.
According to me, it is permissible. First of all, because it says বৈধ পঞ্জীয়ন থকা আৰু নাও ফেৰী চলাচলৰ ক্ষেত্ৰত বাধ্যতামূলক সুৰক্ষা ব্যৱস্থা গ্ৰহণ কৰা নিবিদাকাৰী সকলে ফেৰী ঘাট
Nibidakari Hokole, that means the person who bids, he needs to be the registered owner. If any other interpretation is possible, you can assist the court.
And moreover, my lord, this point was never raised in the writ petition. That I do not have a valid writ petition. Their plea was that same amount, and there was no lottery. And they have not given the police verification report, which is mandatory as per clause.
No,
19.
so for his bid being defective, declared defective, as contended by Mr. Datta, we'll definitely consider.
Yes.
We'll definitely consider. But have you filed a rejoinder affidavit?
My lord.
Have taken this point that he has not qualified?
My lord.
Where? See, Mr. Khan may be right. These are questions of argument based on facts. If you do not plead, we cannot assume.
My lord, we came to know from their.
No, where have you pleaded?
My lord, from their document, my lord, when they.
So you have to make out a case.
We are not knowing, my lord, what he has submitted in the.
Now you are submitting. Where is your pleadings? Where are your pleadings in the reply affidavit? You've said yes. Kindly show us.
My lord, page 127, para 7.
140?
127.
127.
My lord.
Para 7. Please read.
My lord, your lordship may come to page 129. ma'am.
Yes, please.
My lord. Oh. Line about 5 from top. ma'am.
Yes.
The deponent further beg to state that clause 36 of the impugn tender provides that only those bidders who have valid registration of boats shall be allowed to
Okay.
participate in the bidding process
Yes,
of
yes.
the.
Yes. Yes, he's brought this point on record.
My lord, subject to correction, my lord. My understanding is clause 36, my lord, is that they have valid registration, but it's not saying that in their own name, my lord. My understanding.
And who will have valid? Then why a hired board? That person could have come and be the bidder.
That may be, my lord. But this line 36, clause 36 is saying, বৈধ পঞ্জীয়ন থকা আৰু নাও ফেৰীৰ চলাচলৰ ক্ষেত্ৰত বাধ্যতামূলক সুৰক্ষা ব্যৱস্থা কৰা নিবিদাকাৰী সকলেহে participate কৰিব।
Bidders.
Bidder. So it's not saying that নিজৰ নামত থকা।
That will be stretching.
Only because of that
See, the
interpretation
entire,
allowed.
see, if on a holistic approach, if you read the objective of clause 36, what is the objective? It is to ensure safety.
Yes, my lord.
If to ensure safety, you are saying that the boat has to be registered as per your contention.
Yes, yes,
And you have met with all the safety requirements.
yes,
Now, if you are hiring a boat,
my lord.
which of you are not the owner,
Yes.
can you be held accountable and responsible in the real terms?
My lord, I think one.
A
person
registered
like this,
owner,
all are equally responsible.
No. A registered owner, his accountability in vouching for the boat will be different from a person who hires the boat.
My lord. Lordship may kindly have this, my lord.
Which one?
The definition of owner,
Owner of what?
the vessel, my lord.
Owner means operator.
Owner means operator.
Here, there is no requirement, there is no relevancy of owner. We are on the bidder. Who should be the bidder? What are the requirements which a bidder should fulfill as per 36?
In our, my lord, Panchayat Act and the ferries also
What
have
is the
such-
defect? What is his defect?
Defect, my lord, he has not submitted, my lord. Police verification, 107, my lord. Lordship may kindly see.
107.
Yes.
Not 107.
My affidavit, my lord, 107.
Okay, paragraph.
Paragraph, my lord, from fifth line from bottom, my lord. Fourth line, it was found that, where is my lord? It was found that the petitioner did not submit the police verification report as mandatorily required under the terms and conditions of the NIT under clause 19 of the said NIT. It was also found that the passport size photograph pasted by the petitioner on his tender paper was not duly attested by gazetted officer as mandatorily required under clause 17 of the NIT. Apart from that, the copy of the boat registration certificate submitted by the petitioner was not clearly visible, which was required as per serial number 8 of the tender form, and boat insurance certificate was not submitted by the petitioner in his tender form, and as a result of which the petitioner bid was also rejected due to insufficiency of necessary documents as required under the terms and conditions of the NIT.
But why did you go to the extent of declaring his bid?
Well,
He is making out a case that the bid submitted by him and by Mr. Khan were equal.
yes.
So this statement he could have made only when the bids were opened. If he was technically not responsive on more than one count, he have said that he did not have PVR, his passport size photo was not attested by a gazetted officer, his registration certificate was not legible, his boat insurance was not there. So his technically he should have been declared to be non-responsive.
Non-responsive, yes, madam.
So then where is the, why did he open his price bid?
My lord, it's a not a, it's a one single bid only.
Oh, it's a single bid.
Yes, madam. In fact, lordship kindly have 119. This is the comparative statement, my lord.
119.
Yes, my lord.
Yes.
The seventh, the serial number 7 is the petitioner, my lord.
Just a minute, please. Yes.
Serial number 7, Chandmia.
Yes.
is, it's written as rejected due to insufficient documents, my lord. And serial number 8 is the private respondent, my lord.
Respond number
7.
7.
Serial number 8.
Yes. Rejected due to insufficient documents.
Now the question.
No, on your rejection, what are your grounds? Are these grounds stated for a rejection factually incorrect? See, you have raised a point in your reply affidavit.
Well, they have said from the record, I cannot dispute.
Then, in that case, you may not be required to decide the other aspect. You come as a successful bidder, will decide.
He cannot be successful, my lord, because
No, you come as a successful bidder on technical grounds, then we, in an appropriate case, will decide whether a registered owner or a, not in this case, we leave that open.
Because being a defective.
Unless you are able to demonstrate your stand, that you have a right to stand, that you can, the grounds for rejection of your bid are not sustainable in law, then the aspect of deciding the other issue will come.
My lord, from the record, it was before your lordship, my lord, your lordship has seen that.
No, are you saying that at times we have seen that certain grounds are stated for rejecting which are factually incorrect, or you may have a better explanation that indeed you had given the PVR, ignored, you had given a registered, a passport photo with attestation,
No,
ignored.
it is not there, in reply.
Then that point will not decide here. With that point, we'll leave it open to be decided in an appropriate case. We will not express any opinion, either in your favor or his favor. We'll decide in an appropriate case. Okay. Heard. 3. KKD, Learned Counsel for the petitioner. Also heard 3 S. Datta, Learned Standing Counsel, ENRD, full stop. 3 S. Count has appeared for the respondent number 7. Full stop. The pleadings have been exchanged. Full stop. Para. The challenge is with regard to the rejection of the bid of the petitioner which he had submitted for settlement of the Birsing Jogomaya Ghat in the river Brahmaputra in the district of Dhubri. Full stop. Para. As per the facts projected, the Birsing Gaon Panchayat had issued a tender notice on 3/6/2025 for settlement of the aforesaid ghat. Full stop. The petitioner has contended that the bid which he had offered of rupees 99,000 was identical to the bid of the respondent number 7. Full stop. According to the petitioner, there is a prescription in the rules that in the event more than one bid is found to be, more than one financial bid is found to be identical, recourse to drawing of lots has to be made, which was not done. And the bid and the settlement was made in favor of the respondent number 7. Full stop. Para. 3 days. The Learned Counsel has drawn the attention of this court to which section rules that draw lots
The rule 36, clause 36
of
advertisement.
NIT.
The Learned 3 days. The Learned Counsel has drawn the attention of no, not the statistics. The draw of lots.
14A, my lord. Advertisement.
To clause 14A of the NIT, which prescribes that in case the same tender value is submitted by more than one bidder, comma, the same would be settled by holding a lottery amongst the bidders. Full stop. He has submitted that the aforesaid condition has been blatantly violated and the settlement has been made in favor of the respondent number 7 in an arbitrary manner. Full stop. Para. Sri Dr. The learned Standing Council, PNRD, by drawing the attention of this court to the affidavit in opposition filed on 24/10/2025, has submitted that the projection on facts made by the petitioner is not wholly correct. Full stop. He has submitted that the recourse to the provision of clause 14A would be done only when the financial bids of two valid bidders are found to be identical. Full stop. In the instant case, however, the bid of the petitioner was found to be defective on more than one count. Full stop. He has submitted that the petitioner did not deposit the police verification report, comma, duly attested passport size photo. Full stop. Further, the registration certificate of the petitioner was not eligible and the boat insurance was also not furnished by the petitioner. Full stop. In this regard, comma, he has drawn the attention of this court to the comparative statement of the respective bids, which has been enclosed as Annexure 6 to the affidavit in opposition filed on 23/10/2025. Full stop. He has submitted that there is a clear remark in the bid, in the consideration of the bid of the petitioner, that the same was rejected due to insufficient documents. Full stop. It is also, he has also drawn the attention of this court to the remark column, whereby which contains certain reasons of such rejection. Full stop. Para 3, count the learned counsel for the respondent number 7, while endorsing the submission of the learned standing counsel, PNRD, has submitted that the settlement has been rightly given to his client inasmuch as the aspect of taking recourse to clause 14 of the NIT would not arise in the instant case. Para 3D, the learned counsel in his rejoinder has submitted that after exchange of affidavits, comma, it was revealed that the petition number, that the respondent number 7 was also not qualified inasmuch as not qualified in terms of clause 36 of the NIT. Full stop. He has submitted that as per the aforesaid clause, comma, a bidder is required to be the registered owner of the boat, and in the instant case, comma, it is not in dispute that the boat of the respondent number 7 was taken on hire. Full stop. Para. The rival submissions have been duly considered. Para. The primary challenge challenge raised in this writ petition was with regard to the rejection of the bid of the petitioner. Don't say right, don't like this. The primary challenge instituted in the petition was against the order dated 28/2025 issued by the respondent number 6, whereby the settlement of the ghat in question was given to the respondent number 7. Full stop. From the pleaded case, comma, the the basis of the challenge was upon clause 14, wherein there is a requirement to take recourse to drawing of lots when the financial bids of more than one bidder are identical. Full stop. The petition, it appears that the financial bid of the offered by the petitioner and the respondent number 7 are the same. Bid is the same. Full stop. However, it transpires that the bid of the petitioner was cancelled, in which is reflected from the comparative statement enclosed to the affidavit in opposition. The rejection of the bid of the petitioner as such is not the subject matter of challenge. Full stop. The learned counsel for the petitioner has also fairly submitted that the grounds for such rejection are based on records and the same can be verified only from the records. Full stop. As mentioned above, the grounds as elucidated in the affidavit, as well as which appears from the comparative statement, is that the petitioner did not have the requisite documents for required for consideration of the bids. Full stop. The Learned Standing Council has highlighted 4 defects which have been mentioned above. Para. At this stage, this court is also required to consider the submissions made by Sri Dey that the petitioner's bid is also not defective, being in violation of the requirement of clause 36. Full stop. Para. Though there is no dispute in law that averments made in a reply affidavit can also be treated to be a part of the pleadings, this court is of the opinion that when the petitioner has failed to make a specific challenge with regard to the aspect of cancellation of his bid, the aforesaid question of deciding the legitimacy of the bid of the respondent number 7 may not arise in the present case. Full stop. In this regard, one may gainfully refer to the decision of the Honorable Supreme Court in the case of so-and-so 1963 so para. In the conspectus of the aforesaid discussions, this court is of the opinion that no case for interference is made out and the writ petition is dismissed. Full stop. This court, however, clarifies that the aspect of the validity or otherwise of the bid of the respondent number 7 is not decided in the present case, which should be done in an appropriate case.
Highly obliged.
After the line is validity, the requirement of a bidder to be the registered owner of a boat or whether such boats can be hired would be decided in an appropriate case.
Highly obliged.
Yes, next.
May I please? See, in this case, Senior Counsel Sri Rahul Pant from Jammu and Kashmir High Court is appearing, Lordship, in the matter. He is midst of the hearing of a matter. Lordship,
Item number
15, Lordship. However, Lordship, if peruse the order dated 16/12, this matter was subsequently heard by my Lord Justice Sri Devassis Buru and accordingly fixed the matter today at 2 p.m. Lordship. I think this is.
Is it okay? Then we'll have it before. Okay.
Yes, Lordship. Lordship, may peruse the 16/12 order also.
Yes. Both Sri K. Kolita, learned counsel, K. Kolita, learned counsel for the petitioner, and Sri H. Gupta, learned CGC, has submitted that this matter was heard substantially by a coordinate bench. Within bracket Justice, Honorable Justice D. Barua. And the matter was in fact fixed for further hearing at 2 p.m. today. Full stop. You're also appearing, Mr. Vata?
My lord, I am the private respondent, my lord.
Okay, then hearing. Both Nakoba.
The successful bidder.
And the learned counsel for the parties, namely BC Pathak, for the respondent number
11.
11. That's the code. Raised to verify and list this case before the appropriate bench. So, we'll not be able to give a date. Depends on.
In fact, the bench is probably not available.
Not available next week.
Next week, as and when the bench is available.
Hello.
Lordship, my senior is in election, some other.
Item number?
16, Lordship. Kindly pass over the matter for the time being.
Yes, 25 matter. Are you filing affidavit, madam?
Lordship, we have received instructions. 4 weeks' time may be granted.
You have received the instructions. You want to file affidavit. Okay, madam. Okay. What is your name?
Edas.
Heard Miss A. Das, learned counsel for the petitioner. You are Saikia.
A. Saikia on behalf of MD.
Also heard Miss A. Saikia, learned counsel appearing on instruction of Miss M.D. Bora, learned standing counsel, Corporation Department. Miss Saikia, the learned counsel has submitted that instructions have been received and she prays for time to file the affidavit in opposition. Para. Matter accordingly stands adjourned to be listed on 25th of February, by which time?
Lordship, after March, first week of March.
On 4th of February, by which time? 4th is a holiday. On 6th of February, 6th of March,
6th.
by which time the affidavit in opposition is required to be filed. Yes.
Matter. This is regarding allotment of Bazar Pita. And wherein the fact is this, Milord, and they issued a notice, Bazar Pita. Lanka Municipal Board issued a notice stating that, Milord, there are some conditions by which the applicants can apply. And conditions are
Lanka Municipal Board.
Mine.
Notice was issued.
Yes.
Okay.
And notice, Milord, annexer 1 minute, page 15.
Then what happened?
Then, Milord, we applied, Milord, and some other persons.
For
applied-
notice was for allotment of shops.
Yes, rooms. Rooms? Yeah.
Rooms.
Shops, yes. Then, Milord, we petitioner will applied, and also the respondents applied, Milord. But the conditions they are respondents here in Milord, I have given, Milord, RTI copies. Those are, Milord, not fulfilled. As because, Milord, affidavit is required within some time period that is not given, and affidavit is to be executed by the magistrate. Generally, affidavit notary or some, Milord, that is not given. And, Milord, date, Milord, they have submitted them, Milord, after the fixed date. We have calculated function. So, Milord, on that point, my prayer was these, Milord. They prepared a list, so list is illegal, that may be cancelled and fresh notice may be issued. And can you see, Milord, annexer 1, page 15.
Page 15.
Mine.
Yes.
This is the notice, Milord.
Yes.
And requirement, what is the requirement of this, Milord? That is a page, Milord, 17. Is my for submission form. Page 17, Milord.
17.
17, yes.
17, yes.
Here you will a passport size photograph, that is okay.
Yes.
Up to date tax payment receipts, voter ID card, and additional documents, trade license, PAN card, etc. Madam. And affidavit as per annexer 1.
Yes.
Annexer 1, Milord, given below, Milord, can yes. That is the annex, Milord. But when, Milord, we search, Milord, and find some copies of RTI copies, Milord, we have seen Milord from the, in the meantime, we have filed application for RTI, information whatever required, then they replied, yes, these documents are required. Then Milord kindly see. Annexure 15 to 23, page 40,
Page
page 40.
40.
40, yes.
Yes. Four zero.
This is the one of the respondent here, I have added him. There is the Megnapal. So, my lord, he has annexed other documents, but affidavit can be similar, page 41.
Yes.
Here in the affidavit is not found, not fill up. Only Miller it is printed or typed Miller on a 20 rupees stamp, and it is also not signed by her. And similarly, Miller in next Miller page 42, another respondent number 6, and his
This Meghna is respondent number what?
his respondent number Miller respondent number 9.
9. Okay.
Then Miller and kindly see Miller page 42.
Yes.
Jumapal.
Yes.
He is respondent number 6.
Hmm.
And her affidavit kindly see Miller page 43.
Yes.
Affidavit.
Yes.
Only Miller is the it is Miller typed and 20 rupees deed Miller stamp and only signature in the deponent, but that is not executed before any magistrate or not. In the article Miller. And page Miller 44. Is another respondent Miller, respondent number 7. Aparajit Das. 44 minutes.
Yes.
In his Milad, page 45, he is affidavit can be seen Milad. Same Milad, only form is fill up, date is not given, only signed there, but no notary signature is there.
Yes.
And annexure Milad 18, page 46. She is Milad respondent number 10, Nilufar Yasmin, and her affidavit is also similar Milad, without, yes, it is Milad signed and sealed before the notary Milad, but date is kindly similar, date is given 18 July 2019. What is the cutoff date was 1st of March, yes, 1/3/19, 1st of March 2019. And her affidavit was executed 18th of July 2019, and notary signature also 18 July 2019.
And cutoff date was?
1/3/2019. In notice Miller says.
So you want to contend that after the cutoff date, the
Yes. So after that, yes. And kindly see that again, page 48.
48.
48, yes. And page 49, page 49 will affidavit, that is the Bina Das.
Respondent number?
Respondent number is 11.
Yes.
Her affidavit will kindly see page 49. Her affidavit was shown on 11th of March 2019. When the cutoff date was 1st of March 2019. That is after the date it was submitted. And then Miller kindly see annexure 20, page 50.
Yes.
Wow, it's original. His affidavit Miller kindly see page 51.
Respondent number?
Is in respondent number 12.
12.
Right. And
yes.
51 is his affidavit. Hearing Milan date is not there and affidavit was not typed on a stamp paper, only a white paper Milan and without any execution by or magistrate, nothing. So it is defective.
Yes.
And Annexer Miller, page 21, page 52. Onita Pal. In his Miller, her affidavit says on page 53, without even will only type some portion, but without her.
As per number?
His respondent number 13. 13. Page 53 Miller. Affidavit was typed, but without stamp and without filling. As in 53, as you see. And then you will see page Miller 54. Ruby Bordoloi. She is respondent number 14. And her affidavit Miller page 55. Same. Without filling up, without signature of magistrate or notary, only her name was there in the deponent portion, and even date is not also filled up. Then Miller University kindly see page 56 and answer 23.
Respondent?
Respondent 15. 15. Onita Otto. And her affidavit Miller page 57.
Yes.
Similar Miller without signature, without only signature is there, without date and without filling up the form and without stamp also Miller. So all are Miller defective. And on these grounds, Miller, my challenge will Lordship is the selective should be paused. And on last minute, your similar case was heard by your Lordship, and that was Miller on 15, sorry.
WPC number?
WBC 1612, WBC number Miller 845422. By another several advocates and another Miller petitioners.
Dated?
Dated Miller 16/12/25.
What was the finding of this court?
Finding was this Miller the petitioners paid some amount and Miller, so your Lordship was pleased to Miller direct them to complete the construction. And my learned friends informed the dishonorable court that there was an inquiry committee. Inquiry was Miller. Inquiry. Yesterday I have given a copy of Lordship whether there is there or not. সত্যব্রত দে কালি দিছিল আসেনি সত্য ওয়ালাইকুম
Not there. Doesn't matter.
No. It is as per order dated 14/11/25, an inquiry committee appears to have been constituted, which is revealed from the evidence opposition filed by the respondent number so on 14/12/25. Learned Council accordingly submit that the appropriate order will be passed by following the petitioners to complete the sanction. Similar, the still inquiry is going for regarding the construction, etc. So inquiry is not completed. Only 14/11/25 minutes. So your Lordship knows the date minute. Same. Your Lordship knows. There is some short margin. In paragraph 4 is there, your Lordship. So on the basis of my submission, Lordship, the list which is prepared by them, Milord, that is totally illegal and without Milord, in violation of the notice, Milord. So Milord, that no select list may go and fresh notice will be issued for the fresh selection. But we are deprived, but some other many persons deprived anyway, that is not my concern. Also, we are deprived, we are some persons, 7 persons here, Milord, 7 or 8 persons.
7 petitioners are there.
My lord. It's totally 8 Milord, sorry, 8 persons.
8 petitioners.
Let a minute, selectively be prepared as following the procedure, Milord. We have no objection to that, Milord. But without any document, without any affidavit, with their notice.
Why your bids were declared to be defective?
No, we are not defeated. We are not selected here, simply.
No, why not selected?
Selected, Milord, there is no reason has been given. We have applied, nothing. Nothing is there. We have applied as per procedure, Milord. Photo, voter ID, and this affidavit. And PAN card or some etc.
Okay. Yes, Mr. Nath.
Well, out of 8 petitioners, petitioner number 2 and petitioner number 3, they have been given, they have been allotted vita. In our affidavit, we have said in para 10, affidavit has been filed. Can you take up the affidavit of the respondent number 4?
Yes.
2 and 3, they have been allotted vitas. Well, basically, their grievance in paragraph number 8, 9, 10, and 11. These are the allegations. And to which we have replied that 2 of the petitioners, they have been selected and they have been allotted vita in the first floor and second floor. Petitioner number 2 in the second floor, 3 in the first floor. My
Actually,
learned
copy,
learned
probably I
friend
have
said
not
that
received the copy, I have not used.
he doesn't have the copy of the affidavit.
Maybe. That is the problem. Anyway, if there is given.
It is filed in 2020, Malad.
Sir Rashid, you have received it.
Then I have missed it. I have not in my file. That is a sorry. Anyway, let's me pass.
It was not received by anybody else but by you.
Maybe will not. Right?
Yeah,
I have either misplaced or my record generally it is kept as well as I'm checking.
Unless you dispute your signature.
No, I am no, I am agreeing that.
No, you see,
No,
had it been
probably-
somebody else's signature, matter would have been different.
Others. Yeah. No, I have.
See, have a look, Mr.
No,
Nath.
the lordship has seen it, so my generally what I receive, I can.
Unless you dispute your signature,
No, I'm not disputing.
not disputing. So you have received the affidavit.
The record is not, it is.
If necessary, I can give one, but
No, but we're not adjourning the matter for
Lot-
that.
No, I'm not,
See, you said that 2 and 3 have already been allotted.
yes, they have
How
been
many
allowed-
petitioners were there, Mr. Rashid, total?
8
8. So 6 remains.
6 remains.
Yes.
Malad, in fact, we have categorically said in the affidavit that applications were not received after the due date, and the petitioners' applications were not submitted with some relevant documents. That is why other petitioners, they were not considered. And Malad, one vital aspect Lordship may kindly consider, although many of the persons have been implicated as private respondents, no pleading has been made in the writ petition. In paragraph 15, kindly come to para 15, the documents were annexed in para 15, annexure 15 to annexure 23, but no statement has been made. No allegation has been made that again.
Paragraph?
Para 15. From the para 15, they said the respondents have selected private respondents and others for bazaar rooms in purely Fukan market, first floor and second floor in illegal and arbitrary manner. Hence, the select list of bazaar room in purely Fukan so and so is liable to be set aside and quashed and fresh application be invited. That is the statement. Apart from that, referring to the annexures, what the petitioner wants to refer to the annexures, that how he is agreed, nothing has been stated. And my lord, it is also, they have also not annexed the, in fact, the, whether private respondents, I think the private respondents, no.
Yes.
In the affidavit, para 13 and 14, we have stated in detail what procedure have been adopted for selection of the allottees. The applications were invited, ultimately those were verified by the board, and after taking decision by the board, those are given. Some of the petitioners have also, only after when they were not selected, they come and they have leveled some allegations. Those are not pinpointed. So at this stage, what I would like to submit, but 6 of the petitioners, the other petition, if some of the rooms are still vacant, and they had submitted the applications properly, proper applications. Now the board will examine and they will.
The committee for examining, is the committee also looking into the aspect of anomalies for allocation of shops?
That no, the inquiry, whatever has been referred by my learned friend, the deputy commissioner has initiated an inquiry. That inquiry is against the construction of the building by the
Equality, if you remember.
Quality, not
for allotment.
Not for allotment.
That made an observation. It's not per se for quality of the construction.
Yes.
It will not.
Yes.
In fact, that case, the petitioners were not similarly placed at Mr. Rosid's time.
Yes.
They said that they were to be allotted, but because of this inquiry, everything has been.
Yes, my lord. Those were already selected persons.
Only my submission to Lordship at that point is the allotment
But
procedure
just a
is
minute,
not
just a minute. But at the same time, it will be it will not be consistent in your submission. How can we direct this committee to look into the grievance of the petitioner if that committee is per se constituted only to look into the quality of the construction?
No, I'm not submitting that. This committee is constituted by the deputy commissioner.
Yes.
Deputy commissioner's committee is headed by the ADC, and that committee is looking after that aspect.
Yes.
What I am submitting, my lord, the board at that point of time is no longer there. Now new board has come. So they will, whatever documents at that point of time they have filed, if they say that we have filed duly, those are.
But
considered.
we don't want directions from us to be futile. If there are no available rooms, where do you accommodate them?
That is one aspect. That is one aspect.
Are you making a statement that there are rooms, there are vacancies where they can be considered? If there are no vacancies, making this kind of an observation will not be proper.
I can just telephonically in 5 minutes I can ask if anything is available. That I'll advise you.
How serious are you in your challenge?
Actually, my instruction is very that they have orally.
Are your clients serious in this challenge?
My lord, I am trying. And instruction is there where there is some rooms are.
See, you don't want to unsettle things if they are not very serious. If you are serious, yes, you're trying to make out a case from the annexures. But Mr. Nath is right. With proceedings, there is no a single pleading. How it is arbitrary?
Without any pleading.
No, the annexures are incomplete. By which they are selected.
You have not said anything.
So that is.
You come to paragraph 15. There is only a paragraph of 4 lines that the respondents have selected the private respondent others for rooms in illegal and arbitrary manner. Hence, the select list is to be set aside. What is the illegality?
I have shown your lordship that the date of affidavit, date of submission.
Where have you stated?
All these may not be.
Have the private respondents appeared?
No.
Not appeared. Served.
Well, that the service possibly report was to be changed.
It is long back. It was statement taken in 2020 years.
Return of the 2020.
Yes.
6 years almost.
And now they are occupying and they are possibly they have started. No, only but with vague allegations. What to respond in paragraph 15? Nothing is there. He has annexed the documents, and during the verbal submissions only we came to know that he is agreed by that on that document.
Only that's why submission.
Yes, where have you stated that you have received, you have obtained this application documents of the private respondent by RTI? That also you have not stated.
The forwarding letter has not been given. I don't know where from this has come.
No, RTI Milord, we have one of the person file application and.
Where have you stated? Where is that application? Where is the response? The forwarding letter, at least that would have thrown some light.
Page 23, Milord.
23. 20?
This is the application, Milord, and Milord.
23, yes, 23, yes.
And page Milord 25, the information instruction will be given to that person, Milord.
Yes.
To see responsive, Milord, information under RTI Act, Milord, with reference to the subject schedule. Here the information was sought for. Information 1, details there is to be applying for closed. Information 2, list and closed.
He is not a petitioner.
He is not
not a petitioner.
Yes.
He is not a petitioner.
And
No,
information.
therefore, even if it's not a petitioner, if some documents have been,
All these documents mentioned.
we may not be too rigid in that respect, but some bona fide has to be demonstrated by you.
Lordship.
You are not being able to demonstrate the bona fide, that's the.
Then last,
Rashid.
Milord, list and closed, the Milord, that trade license not issued. Only Milord, here one list has been given and document given, Milord, from this.
What do you suggest, Mr. Nath?
But let me have the information.
No, we are not adjourning that.
I need 5 minutes time.
Okay, you get it.
Within 5 minutes, I'll.
Okay, you come back. We will dispose this.
If any room is there, then Lordship may say.
Yes.
Subject to availability of their documents, if they have validly submitted, they will.
But it cannot be a direction for only their consideration. It has to be considered along with similarly situated person.
The valid documents.
Only because they are in the court, we cannot direct. It has to be along with similarly situated. Process of fairness has to be
Yes.
maintained. Okay, you
Yeah.
come back after some time.
Yes, 5 minutes. Lordship.
My lord, I have filed the IA, my lord. IA 4140 for vacation of an ex parte interim order, my lord. Now, the matter relates to appointment of a dealer of petrol pump. Lord, when the writ petition was assailed or filed, the letter of intent was assailed. But during the pendency of the writ petition, my lord, even the appointment order has been issued, but they have not challenged it. And they will be filing. Now, be that as it may, my lord, if a lord.
Your response number?
I'm 6.
Yes.
My lord will kindly come to the impugn order just to appreciate, my lord. It is an ex parte order, therefore, my lord. The order starts at page 18. If your lordship would kindly
Of
come
the repetition?
of the IA, my lord.
IA.
Yes. IA 4140.
Yes, page 18.
Yes. Please come to page 20, para 8.
This is the interim order.
Yes. Of which we are seeking, my
Please,
lord.
what is the date?
Date is, my lord,
8/9.
8/9/25.
Yes.
Para 8, the learned counsel appearing on behalf of the petitioner submits that grievance of the petitioner is based upon 3 grounds. First, to come within the MPW Group 1 in the draft lots, the candidate either should have a land of his own or should have a long-term lease of not less than 19 years, 11 months. But the learned counsel for the petitioner has drawn attention of this court to the lease deed dated 17/10/23 that the lease is for a period of 20 years and the annual rent reserved was 60,000. The learned counsel, further drawing attention of this court to the stamp duty paid, submits that total consideration has been taken at rupees 1,20,000, which is far too less taking into account Article 35 of this Indian Stamp Act, insofar as it is applicable to the state of Assam. He therefore submits that the said documents could not have been taken into consideration as the said document was insufficiently stamped. The second ground on which the petitioner has assailed the selection of the respondent number 6 is not compliance of clause 47B, which relates to other backward classes. The learned counsel for the petitioner submitted that at the time of submission of the document on 17/10/23, respondent number 6 did not submit the document as per Appendix 7A. The document which was submitted as annexed at page 133 to the writ petition is a document of the year 2014. The learned counsel submitted that the reading of clause 7B categorically mentions that the date of document has to be subsequent to the advertisement. Under such circumstances, the respondent number 6 could not at all have been brought within the ambit of draft lots in respect to the retail outlet in question, as the retail outlet was specifically reserved for OBC. Milord, the third ground is a ground of fraud because of 1 and 2. Am I clear, Milord? Taking cognizance of these 2 grounds, Milord, my letter of intent was stayed, though in the meantime, Milord, order of appointment was also issued. Now, Milord will kindly take the writ petition for a moment, Milord. I'll show Milord why this is not correct. Now, what is the first requirement? Please come to, Milord, page number 36 of the writ petition. Hyper-technical approach has been taken, Milord. Kindly see. Page 36. This is 4 Roman 6.
Land.
Yes, Milord. Land. Either one should have his own land, or if it is a lease land, it should be minimum for 19 years, 11 months.
Yes.
No further specification, Milord. Applicant having suitable place of land in the advertised location area, either by ownership or long-term lease for a period of 19 years, 11 months. Now, Milord will kindly come to page number 123.
Of the repetition.
Yes, if I had paid less court fee, Milord, then it would not have been registered. How this is relevant, Milord? Please come to page 123. 17th October 23 is the date. Stamp duty of 3,700 was paid. Actually, we are required to pay 3,600. We paid 100 rupees more. So this is the registered lead, Milord. Kindly come to page 125. Period 1, period of lease shall be 20 years commencing from
135.
page 125.
125.
Yes, I'm sorry, Milord. Page 125.
Period is not this dispute. The dispute is with some stamp duty being deficit.
Milord, if stamp duty is not paid, then Milord, it will not even be registered. Is appropriate not paid. And where is the requirement, Milord? Where is the requirement in the clause? All that is required is either I must give documents showing I own a plot of land, or if it is a lease, it has to be registered lease up to minimum 19 years, 11 months. So in my humble submission, Milord, this ground is neither here nor there. Therefore, I think the learned single judge, the coordinate bench, Milord, wholly misconstrued the whole thing. And then Milord will kindly come to the second point. Second point is regarding Milord that
OBC.
OBC. He himself is not an OBC Milord. He is a Chauhan. He is from Bihar. Under the central list also for Assam, Chauhan does not appear. This repetition is not maintainable. Milord, actually, Milord, in respect of 7A, it could be a document dated before that. Only in respect of Milord 7B, it has to be post the last date of
Where is
submission.
7A?
I'm placing it, Milord. First come to page 42.
Of the repetition.
Yes. Kindly come to that 47B, other backward classes.
42.
Page 42, Roman 7B.
B, yes, OBC.
Yes, other backward classes. The candidates belonging to other backward classes recognized as OBC by the Government of India, kindly similar, central government, under Constitution of India, or recognized by concerned state as OBC in which the location has been advertised will be eligible. The candidate will be required to submit as and when advertised by oil company a certificate issued by the competent authority notified by the Government of India or by the concerned state in which the location has been advertised, certifying that the candidate belongs to the other backward classes recognized as OBC by resolution gazette notification issued by Government of India state government. Along with the OBC certificate, that is Appendix 7A, candidate also has to submit an undertaking, that is Appendix 7B, that she belongs to OBC category and fulfills the non-creamy layer status. Date of undertaking will be treated as the date reckoning the OBC status of the candidate and also for determining that the candidate does not fall in creamy layer. Now, this is important. The undertaking should be of any date after the date of advertisement. That means, my lord, 7B has to bear a date post the date of advertisement. But in respect of 7A, there is no requirement. My lord, if I am a OBC, even if I give a certificate of 20 years old also, how is it defective, my lord? Now kindly come to the order for a moment of the learned single judge, my lord. Why this order is bad, my lord? Please come to page 21 of the IA.
Page 20.
Page 21 of the IA. Yes, I gave a certificate of 2014. There's no difficulty. 7A.
21A.
Yeah. Page 21, my lord, para 9.
Yes.
Now, fifth line. Document which was submitted as annexed at page 133 to the writ petition is a document of the year 2014. Yes, it is a fact. The Learned Council submitted that the reading of clause 747B categorically mentions the date of document has to be subsequent to the advertisement. This is also correct. Under such circumstances, respondent number 6 would not at all have been brought within the ambit of draw of lots. Now, my lord will kindly come to the certificate which we have annexed, my lord. As far as this certificate is concerned, it is at page 133. A. 7A.
Page?
133. It is of 714, my lord. There is no dispute.
133.
No, 133. Yes. 28-114. Non-creamy layer. Subsequent is also there, but this is also there, my lord. So, my lord, the learned single judge has taken the view that this should not have been of 2014. It should have been of the date post the date of advertisement, and the date of advertisement was, my lord, 28/6/23. Now, regarding the undertaking which requires to be, my lord, of that we have given, my lord, that lordships will get in our affidavit in opposition. Page number. In the affidavit in opposition, my lord, at page 277. 277. Is the type copy, original is at 278. Affidavit in the writ petition, my lord. Easy.
Affidavit.
Yes, no, affidavit in opposition of R6. It starts at page 258. And the certificate undertaking is at 277.
Yes.
And he is a son of the soil miller. Sumitra Nath, son of Sanat Kumar Nath, resident of village so-and-so in the district of Kasar, Assam, hereby declare that I belong to OBC, which is a recognized backward class by the Government of India for the purpose of reservation in service as per the orders contained in Department of Personnel, training dated so-and-so. It is also declared that I do not belong to person section of Creamy Layer mentioned in column 3 of the schedule to the above referred OM, which is modified by Department of Personnel, order dated so-and-so. 15/10/23.
Yes.
So learned single judge, the coordinate bench misconstrued this with the Milord 7A also. That is a 14 document. So Milord, what is the fraud? Now coming to the petitioner, Milord. He says.
Now, third ground of fraud is on what?
But on account of A and 1 and 2, there is a fraud. On account of 1 and 2. 3 is a fraud on account of 1 and 2. Now, my lord, let us come to the status of the petitioner. He admittedly, he is one Raju Chauhan, my lord. Now, he doesn't belong to the state. Now, the issue is whether he may belong to UP, he may belong to Bihar, or he may belong to any other state of the country. But question is, either you must be recognized as an OBC by the state of Assam or under the central list.
Yes.
Now, central list ko copy kar diya. Nahi.
But his surname may not determine his case.
But let me explain how he is an OBC. What is his subcaste?
Has he given the certificate?
Nothing. He has given a certificate. My lord, yesterday Supreme Court was dealing with a matter where a Milord upper caste person converted to Buddhism and he got a certificate as a scheduled caste. And Milord sought medical admission in a state of UP. The Supreme Court stated, Milord, that certificate is nothing. End of the day, you must establish your credential. Now, he must be an OBC in the state of Assam by virtue of the central list for the state of Assam. This is the central list. Assam though is not there. Prima facie, Milord, unless he can rebut it. So when the petition is not, it does not include any Chauhan or any other tribe, Milord. It is central list for Assam. I think as far as other than Milord indigenous people, there are few, for example, Dhanuar, then Milord Lodha, then I find Basfor. So these are all Milord, this is the central list. Is not included. So his very credential itself is doubtful, Milord. Whether he is a OBC, he has to first establish. If you are not an OBC, how can you question the OBC status of somebody else?
No, that question we can decide at a later stage.
Yes.
You are primarily concerned with the continuation or otherwise of the interim order.
In any
And you are
case,
trying to
Milord,
demonstrate that the interim order has been passed on considerations which are factually incorrect.
Incorrect.
And probably on a misinterpretation
of
the requirement of the documents as per A and B.
Besides.
That is your case. Yes, Mr. Chakraborty.
Wait, please, your lordship. My lord, to start off with, my lord, insofar as my credential.
No, we are not on
We
your
are not.
credentials.
My lord, insofar as the third ground on the basis of which the interim order has been passed, if your lordship allows me to read that for a while, my lord. The third ground, that is in the IA,
the interim order that has been said. If your lordship takes up the third ground for a while,
Yes,
that is at page 21,
Yes.
paragraph number 10.
yes, please.
The third ground on which the petitioner has urged upon is that the candidature of respondent number 6 could not have been accepted on the ground that the respondent number 6 had indulged in committing fraud. The learned counsel submitted that pursuant to the last date of submission of the tender, the respondent number 6 initially submitted a document in Form Appendix 7A, which was dated 21/12/2023. Subsequently, he manufactured a document dated 6/9/2023, which is also in Form Appendix 7A. The learned counsel submitted that an information was sought for as regards the authenticity of the document dated 6/9/2023, and it was informed by the Additional District Commissioner Kachar that no such document dated 6/9/2023 in Appendix 7A was issued in favor of respondent number 6. The learned counsel therefore submitted that this is a fit case wherein the allotment of the retail outlet in favor of respondent number 6 is required to be interfered with, as well as the letter of intent which was issued. Now, my lord will kindly appreciate this aspect vis-a-vis the documents that I have annexed with my writ petition, first of all, and
Yes.
then I'll take your lordship to the affidavits which have been filed by the IOCL and the additional deputy commissioner. Your lordship, first of all, takes up my writ petition.
Yes.
Now, in the writ petition, your lordship sees the 7A certificate, which was submitted by respondent number 6 before the ISPL authorities. That is at page 134. Your lordship sees page number 134.
Yes,
This is the appendix 7A
yes,
issued by the additional deputy commissioner Kachar, and the date is 21/12/2023. Your lordship will see the date below the signature.
yes.
Now your lordship kindly sees,
What is the
Page-
certificate?
this is appendix 7A.
7A,
7A, appendix 7A,
OBC certificate.
OBC as well as non-criminal.
Okay, but issued by the,
Issued by the, this is issued by the additional deputy commissioner Kachar. And the date is 21/12/2023. Now, if your lordship kindly takes up page number 141.
141.
141, my lord. Now, this also is appendix 7A, and your lordship kindly says the date is 6/9/23.
Yes,
Now, my lord, my limb of argument before the honorable single judge was that insofar as the brochure is concerned, the brochure in the particular clause nowhere stipulates that it has to be on or before the date of submission of the application form. It is up to the IOCL authorities. They can accept it at any point of time, given point of time. But here is a case where there was a document submitted on 21/12/2023, and then there is another document submitted on 6/9/23, shown to have been submitted on 6/9/23.
yes.
And on RTI application, the reply came that there is no such document dated 6/9/23 that was ever issued by the district administration. That is from the office of the deputy commissioner.
Page,
That
Yes.
RTI reply, your lordship will kindly see at page number 151, if your lordship kindly takes up for a while. My lord, will kindly see
151.
My lord, that is not the RTI reply that I am referring to. RTI reply, if your lordship kindly takes up page 142. Your lordship has seen that 141.
Yes,
Now, page 142, this is the reply to the RTI application that is issued by the additional district commissioner on 28/2/2025. With reference to the subject cited above, it is to inform you that as per records available at this office, has not issued any type of appendix 7A on 6/9/23 in the name of Sri so-and-so. so and so, so and so, who is respondent number 6 here. So this is the reply that we received pursuant to our RTI application that there was no such 6923 issued. Now the question arises, my lord, then why this 6923? It could have been 21/12/23, and in fact, my lord, the affidavits which have been filed by the IOCL and also by the respondent number 6, there it has been stated over and over again that for consideration of or for accepting his candidature after the draw of lot, the document dated 21/12/23 has been taken into consideration. 6923, regardless of the fact as to whether it was or it was not issued, that has not been taken into.
But what about the certificate of 14?
No, that is the OBC certificate.
OBC, yes.
7A is the accompanying requirement as per the brochure. That has to be issued by the district administration.
Let us see what is the requirement,
Yes,
7A.
your lordship kindly sees in the
Page-
brochure, page 42.
42.
Well, now, your lordship kindly sees
Yes.
B, clause
And
7B.
yes, yes.
The second paragraph I'll read, my lord. The candidates will be required to submit as and when advised by oil company a certificate issued by the competent authority notified by the Government of India and or by the concerned state in which the location has been advertised, certifying that the candidate belongs to other backward classes recognized as OBC by a resolution, gazette notification issued by Government of India, central or state government. Along with the OBC certificate, Appendix 7A, the candidate also has to submit an undertaking, Appendix 7B, that he or she belongs to OBC category and fulfills the non-criminal.
Where is Appendix 7A?
7A 134 is the 7
100,
page
100 of the report.
100.
No, 100 no. 130, 130, 134 is the 7A certificate.
No, 100 is 7A.
That's the format.
Page 100, yes. In the brochure, that is the format.
And no, we're asking about the brochure only.
Yes, my lord.
What is wrong?
Yes,
No,
this is the brochure format 7A. Now, pursuant to this format, your lordship has seen page 134. Pursuant to this format, the respondent number 6 submitted page 134, issued by the additional deputy commissioner. Exact. This is the format, and this format has been followed, and this was submitted. Your lordship has seen 134, that is dated 21/12/2023. My lord has got 21/12/2023, page 134.
Now, this prior to that, the certificate at 133.
Yes, that is the OBC certificate.
Yes. Is there any validity of this certificate?
No, this, my lord, my argument on this certificate was that it is of 2014.
Yes.
Which in my humble contention, as per the conjoint reading of the clause, ought to have been along with Appendix 7B after the advertisement. But my lord, that aspect is, my lord, something that.
No, see, Mr. Chakraborty,
My lord.
the requirement of giving an undertaking post the advertisement is only to assert that you belong to the non-criminal layer.
My lord, my lord.
The status does not change.
My lord.
Status would change by your income, that either you come out of the criminal layer or you are inside the criminal layer.
My lord,
But your status as
My
OBC,
lord.
OBC per se is not questioned here.
Right.
The requirement to give the 7B, which is after the advertisement,
My lord.
is only to ensure that at the time of the consideration,
My lord.
you are not in the criminal layer.
Nice.
You are in the non-criminal
My
layer.
lord. My lord.
That he meets. You are raising a contention of fraud because 2006/9/2023 is denied by the authorities. You may have a point.
Here.
You may
another-
have a point, but will that point be a relevant point for adjudication at this stage?
My lord, my humble.
If those are ignored,
My lord.
can you make out a case that he still does not meet the requirement?
No, here, my lord, my.
See, we are at the stage of vacating or extending the interim
I
order.
understand, my lord. I understand. My humble contention at this stage, my lord, I have.
See, we are again, we are clarifying
My lord.
that the issue of fraud is a very important issue.
Yes, my lord.
We are not ignoring
My
even for a moment.
My lord.
It may be a point for the final adjudication whether with these papers his candidature could have been considered.
My lord.
But ignoring that aspect for the time being, we have to examine whether he otherwise fulfills the requirement.
Right.
There is a OBC of 2014 accompanied by an undertaking post the advertisement that he belongs to a non-criminal layer.
My lord,
This appears to be without any dispute.
my lord.
The extra thing which the petitioner in the jest has done is probably giving another certificate in the format where there appears to have been some kind of a mischief,
My lord.
which we will consider definitely.
My lord, my humble contention here in regard to the point of fraud, that, my lord, is, my lord, this emanates from a requirement that was placed by IOCL and something that in the affidavit filed by the IOCL. it
So
has been
one,
not
Mr.
protected.
Chakraborty, one thing which relevant thing would
Right, right.
be whether IOC had this 14 certificate was considered by the IOC or not. If 14 was considered and accompanied by the undertaking, then our thinking at this stage may be different. If 14 was not there on records, it has been here, but I don't think it's not there on record because it's a document procured by you as a part of the proceedings which the respondent number 6 had given.
My lord,
It's not that it was introduced by the respondent number 6 here in these proceedings.
my lord, so far the 14 document is concerned.
Yes.
That right now, my lord, I am not on to. I am on that 7A dated 21/12/2023 at page 134. And the same 7A certificate by the same issuing authority at page number 141. That is, my lord, I am confining my entire argument to this.
No, 7A,
7A,
7A you read with 133.
well, that is what?
If
130.
you read 7A along with 133,
Yes.
7A is in a particular format, but
Yes.
what is the content? Content is to ascertain that you belong to OBC.
Yes.
Now 133 come to 133.
My lord.
133 is a certificate that he belongs to OBC.
My lord.
Jogi.
My
He
lord.
belongs to the
My
OBC.
lord, that is of 2014.
14.
Whether 2014 could have been considered by IOCL given the fact that OBC certificate validity is normally for a year.
No, normally from where? Where do you get it?
My lord, this is a non-criminal year certificate.
No. That is why, that is the requirement of a criminal, non-criminal will depend on your income, many other factors. So that is why there is a requirement that you should give an undertaking that you belong to the non-criminal. And it has to be of a contemporaneous period, which he has done. The status as an OBC remains. You don't change.
For the time being, my lord, the status of respondent number 6 as an OBC is something that, my lord, I am not harping on. I am only on that 134 vis-a-vis 141.
Yes.
What necessitated the respondent number 6 to submit 2 documents of same nature?
Yes, IOCL, what documents were there you had considered?
Sequence of 7B and 7A. 7B is the undertaking order which precedes the issuance of 7A. Now, my lord, we kindly come for a moment to page 176.
Of the repetition.
176.
170. Yes. What is this?
The second paragraph.
Just a minute.
170.
Yes. B, this is 180 actually, 180. OBC first. B, you are 180. Yes, please.
The candidates required to submit as and when advised by all the companies. A certificate issued by the competent authority notified by the government of India and or by the concerned state in which the location has been advertised, certifying that the candidate belongs to other backward classes.
That is the same thing which is just same thing.
The document at 4B.
Yes.
That affidavit from record number is 15/10/2023, which the respondent number 6 had submitted. Thereafter, the occasion of 7A arrived. And it is the categorical stand of the IOC that we have considered the document at 7A, regarding the OBC status, that dated 21/12/2023, which is as per the language of the corporation. The undertaking has to precede the last date of advertisement, which was 15/10/2023. The last date of advertisement was 17/10/2023. Thereafter, after I was provisionally selected, the document which is dated 21/12/2023, which has been issued by the Office of the Respondent number 4, was considered by the IOC.
What about the other document, 6-9?
But we have no idea what, we do not have record of the document. 6-9 was never considered by us. 21/12 is the relevant document. After I was provisionally selected, that is on record.
You did not consider 6-9. 6-9. Is 6-9 a part of the documents which was furnished by the respondent number 6?
21/12.
6-9.
No.
6-9 was not there.
21/12. Document the occasion for furnishing document 7A will only arise when the applicants in group 1 are provisionally selected. It is after that, my lord, to substantiate the undertaking in 7B. That is when 7A comes. My lord, it is on record. As per the instructions also we have submitted, my lord.
You have the records.
No one. My lord, if your lordship gets the same,
Or was the 14th certificate also one of the considerations by you?
my lord, instructions are silent on that, irrespective of the fact that whether the booking stays or not, my lord. As per the application which was submitted by the respondent number 6, it was the undertaking.
I think you'll have to have the records. We are not passing any orders today. You get the records. We'd like to have a look at the record.
Fine.
If what you are saying,
Yes.
that 6-9 was never a part of the documents given by the respondent number 6, then petitioner may not have a case at all.
Fine.
Even otherwise, for satisfaction on the aspect of whether to continue or discontinue, that aspect may not be a relevant aspect, because 2014 document is there regarding the status as OBC, and he supports the document by an undertaking that he belongs to the non-criminal, and that is as per requirement of the advertisement within the last date of submission of the documents.
Because by the dates here, objectively not the dates are very crucial, because 6/9/2023, apparently the date of the thoughts that was preceded before the issuance of 7B. 7A and 7B, chronologically matter, 7B precedes 7. 7B has to come before 7. 7B is the undertaking. Thereafter, after the first.
No, it may not be correct.
7B is the undertaking.
It's undertaking, but how can undertaking be of a prior date?
Okay, it has to be issued before the last date of advertisement.
That is not preceding 7B.
7B precedes 7A.
Can I just come in, my lord? Perhaps the correct proposition has fallen from your lordship, my lord, basically to ascertain the non-criminal status.
On the
that
date of
undertaking is
application,
insisted
on the
upon.
date of application,
Yes.
there has to be a OBC
Because-
certificate which has to exist prior to even filing the application.
Yes.
And before the last date, an undertaking has to be given
Yes.
that, yes, I belong to the non-criminal.
Because
So-
within a period of
So
1
what
year.
was the
of-
last date?
7.
1710 was the last date.
Yes.
Last date. Then 7B was furnished dated 1510.
1510.
And after
1510
7B was 1510.
1510 he gives 7B.
Yes. Then I was questioned. Then the 7A document was dated 21/12/2020.
21/12/23.
So
The OBC certificate can be given even after the last date.
Yes.
Yes. Because what happens, my lord, and in fact, it's subject to submission from my legal senior.
6-9 was not there.
No. This is as per my instructions, my lord.
Mr. Chaudhary, let him produce the record.
Yes, yes, my lord.
But unfortunately, this court may not be there in the next week. May not be there, it will not be
Lordship will
there.
have it when lordship is available.
But we can have it after 13th.
Yes,
After 13th.
yes.
We'll extend the interim order till
Till
13th. We can have it on Monday itself. We are coming back on 13th. We can have it on
15th, I think.
it'll be 16th.
16.
16th. 13th is okay. Well, heard. Sri K.N. Chaudhary, learned senior counsel assisted by E. Ahmed for the applicant, respondent number 6. Also heard Sri D. Chakraborty, learned counsel for the opposite party with petitioner. Sri M. Sharma, learned counsel, is present for the IOC. IOC, full stop. After hearing the learned counsel for some length, this court is of the view that the records pertaining to consideration of the case of the respondent number 6 is required to be perused. Para, accordingly, Sri Sharma, the learned counsel for the IOCL, is directed to produce the relevant records on the next date. Para, list on 16/2/2025. Para, in the interest of justice, the interim order passed earlier stands extended till the next date, on which the same would be reconsidered after perusal of the records.
Deeply applied.
Deeply applied.
Now, assuming the petition is to be allowed, there will be a redraw of lots amongst the other applicants.
Oh, we'll have that, we'll have that. You raised this issue on the next date also.
Milord,
We will.
Milord, may I pray, Milord? Milord, I am not feeling well, Milord.
Which matter?
Item number 28, Milord. That rickshaw matter, Milord.
Dibbahan.
Deepahan. Last
Dibbahan,
night,
there is nothing to,
Milord, last night I was suffering.
no,
from
it's okay, I'll
dysentery
consider.
and-
But is there anything to decide? We have already tentatively said
Okay.
Dibbahan will be allowed to apply. But other than Dibbahan, that is a health, safety hazard. Some certificate, some standardization has to be there.
Well, that is correct, Milord, but one small. Because we.
Tomorrow we can try.
Not tomorrow, Milord, Monday, Milord.
Monday, this code will not be there. We can try on Monday. Yes, Mr. Nath. Appear.
I have asked, there is no room available now.
Huh? No, not on that. You are appearing in Dibbahan.
No.
Who is appearing in Dibbahan?
Sharma.
Okay, but we'll have some other date.
Then 13th, my lord.
13th, Friday, 13th of February,
Yes, ma'am. 11th or 13th, my lord.
11th, okay, 11th.
11th.
Sri A.R. Bhuyan, learned counsel for the petitioner in WPC Swenson has expressed some personal difficulties and praised for an adjournment. Para. Ms. M.D. Bora, learned standing counsel Transport Department has expressed some urgency. Para. As paid for list on 11th,
11th or lordship? 11th.
11/2. 11/2.
Interim order.
Interim order passed earlier to continue till the next day of list. এখানে করিবা, এখানে মধ্যে পৌঁছে দিবা। $31.
May I please, Your Lordship?
Yes.
Herein the issue is that, Your Lordship, the petitioner here, he was an aspirant to get settlement of a market. In the year of 2024, an NIT was issued by the local Gaon Panchayat authority.
Yes.
In that NIT, the market was included
Hmm.
for selling.
Hmm.
Phase 18, Annexer 1 is that NIT, Your Lordship. At serial number 1, the market is there.
Oh.
And Annexer 2, that is on 26/5/2025, another NIT was issued. 26/5/2025. And the first one is 1/6/2024.
1/6/24.
Yes, the first NIT it was. And the second NIT.
26/5/25.
25. In
Yes.
that NIT, the market was excluded.
Market was?
Market was excluded from settlement process here. And thereafter, this petitioner, Your Lordship, has approached before this round.
Okay.
Now, just 45, Your Lordship, kindly have a look.
4/5.
Yes. Annexer 3. It was issued by the Anchalik Panchayat.
The original.
Yes. Anchalik Panchayat.
What is the name of the Kalgachia?
Kolgasia Anchalik Panchayat.
No, what is the name of the market?
Market name is Tarakandi Anchalik Bazaar.
Where is it?
At serial number 11, Tarakandi Gaon Panchayat, there is.
Serial number 11. You
Yes.
said serial number 1. Serial number 11.
Serial number 11.
Okay.
That means these are the market which are under Kolgasi Anchalik Panchayat.
Okay.
Herein by this letter, your lordship, the secretaries of the government were.
But you said page 18 is the NIT.
Page 18 is the NIT.
Now what is this 45?
45, this is the tender settlement schedule, your lordship.
Okay.
It was issued by the Anchalik Panchayat. By this letter, the concerned Gaon Panchayat secretaries were requested to finalize the God value, wherein the market in question is appeared at serial number 11.
Yes. It was tender schedule given by AP Anchalik Panchayat.
Anchalik Panchayat.
Market at serial number 12, 11.
11, 1. That means
But it has not been included now.
Yes.
Where is the NIT? Include NIT?
Include NIT, that is at page 31 here.
3-1.
Yes. And Tarakandi Anchalik market is not there.
Okay.
In connection with this case, your lordship, affidavit has been filed by the respondent, private respondent as well as the official respondent. And they have stated that the market is a private market.
Yes.
Nowhere they have made any averment regarding approval of the concerned Gaon Panchayat and the government, which is the mandate as per section 107.
What is 107?
And to be a private market, there has to be approval from the Gaon Panchayat and the government.
107 of the rules.
No. Yes.
Of the Act.
Yes.
Section 107. No private husband shall be allowed to operate within the area of the jurisdiction of government.
Without prior approval of the concerned Panchayat authorities and the government.
Yes.
In the last occasion also, instruction was sought for from the department, your lordship, whether there was any approval on the part of the Panchayat and the government. But regarding this issue, your lordship, in affidavit, there is no anywhere any whisper, your lordship.
But
And I have also filed my reply. The reply has already been filed, your lordship. And I have annexed some documents
Yes.
at page 62, wherein the government money has been invested in the market, your lordship, for construction of market sheet.
Where
at
page?
Page 62.
62.
62, 61.
One.
Yes. And page 59, para 6, I have made details statement, your lordship. What are the scheme? What are the scheme used in that market, your lordship?
Yes.
Page 59, para 6. Earth filling there was in the year of 2017 and in the year of 2022 also, and market sheet, these are.
Yes. Yes, madam.
Lordship, we have already filed our affidavit. Kindly see, in our affidavit, page number 67, para 7. The statement made in paragraph.
Just a minute, please. Sixties?
7, para 7. Page number 67.
Yes.
Then the statement made in paragraph 5 of the writ petition being matters of records of the case, your deponent does not admit any statement made therein which are contrary to and or inconsistent with what appears from the said records. It may be mentioned that although the letter dated 29/5/25 was issued by Kalgasia Anchalik Panchayat for settlement of the Hatch fisheries under Kalgasia Anchalik Panchayat, however, Tarakandi Anchalik Bazaar was running over a private patta land. Therefore, the market was excluded in the list of settlement.
Yes.
For that purpose, not.
What about 10? How do you, what is your response to 107?
Lordship, as per 107, it- okay. Slice. Was the trade license was issued by the secretary. This one is
What is this food?
license.
Yes.
Yes.
Yes, Mr. Ali?
My lord, the market is the private market. It was run since 18 years back.
Just a minute. Your first phone number?
That's for number 8.
8.
Here the case, my lord,
Market is running since
18 years. ago.
18 years.
Yes, my lord. Here the case, my lord, I am not a landholder nor any person, my lord. The land is belong to Juranali, who is my uncle, my lord. But petitioner, my lord, made it party, so I was appeared, my lord. I am the uncle of the present petitioner, my lord.
You are not the owner of the, you are not
Yes,
the,
ma'am.
you are the patta holder.
No, my father and my uncle is patta holder, my lord.
They are there or not?
They are still there, my lord. So their appellate party, me, my lord, so I appear my affidavit also, my lord. I clearly stated all of the document, my lord.
In my petition, your lordship, I have made a statement that
And
he
they
is
said
collecting.
that I collect the revenue, my lord. So, my lord, the market was, and they stated, my lord, the market was collect patta land, and they transfer, not to transfer, they are able to reply, my lord. So, these since established of the market was run the private patta land, my lord. The circle officer of the.
What is your name, Mr. Ali?
My name H. Ali, my lord.
No, not
Oh,
your,
my lord,
Suleiman Ali.
Suleiman, my lord.
not Juran.
Not Juran. Juran. Market is run with the Pattalan with the Jurali and Mansol and others, 19.
Oh.
From long back, my lord, the market is run of Pattalan, my lord. Long back. So the NIT was issued, that was only NIT was, but no settlement was still issued, my lord. Since last 18 years, my lord.
What about the first NIT of 2016-24? It was included.
Included.
But no,
when,
no.
when no settlement was issued, madam. When we approached the concerned authority, this is the market is situated about Pathalan. So, my lord, they not issue any settlement order. No settlement order issued, my lord. And subsequently it was excluded money. One time only issue, my lord.
Okay.
Included.
My only case herein is that, your lordship, I am not on Pattaland or that. But the section says that the approval of the government and the government.
Gaon Panchayat has given a trade license.
Trade license, your lordship, I think in the affidavit, your lordship, they have not made any statement.
But what is the wording? Allowed to operate within the area of under the jurisdiction of a Gaon Panchayat without area under the jurisdiction. So what are the area under the jurisdiction of a Gaon Panchayat?
Panchayat is the authority, your lordship. I am
What?
concerned.
Okay. Let us see. Have your seat, please. The instant petition under Article 226 of the Constitution of India has been instituted with the following relief, page 15. As per the facts projected, the concerned Tarakandi Anchalik Bazaar was a part of an NIT published on 1/6/2024, wherein the petitioner was an aspirant. Full stop. However, the settlement was not made. Full stop. Thereafter, on 26/5/2025, another NIT was published in which the aforesaid market was excluded. Full stop. It is the case of the petitioner that such exclusion is arbitrary and unreasonable and also in violation of Section 107 of the Assam Panchayat Act 1994. Full stop. I have heard Sri A.M. Khan, learned counsel for the petitioner. I have also heard Ms. Ann Bora, learned standing counsel, Panchayat and Rural Development Department, and Sri H. Ali, learned counsel for the respondent number 8. Sri Khan, the learned counsel, has submitted that the petitioner is an aspirant for settlement of the market in question, which was rightfully included in the NIT dated 1/6/2024. Full stop. He has also drawn the attention of this court to the tender schedule issued by the Kalgachia Anchalik Panchayat, in which the aforesaid market finds place against serial number 11. Full stop. However, in the impugned tender notice published on 26/5/2025, the market in question has been excluded. Full stop. He has submitted that from the affidavit filed by the department as well as by the private respondent numbers 8, it transpires that the market is on private land. Full stop. However, that by itself would not overcome the requirement of Section 107 of the Act of 1994, which requires prior approval of the concerned panchayat authorities and the government. He has submitted that no such approval has been brought on record. Para. Per contra, comma, Ms. Bora, the learned tenant counsel, comma, by drawing the attention of this court to the affidavit in opposition filed on 11/11/2025, has submitted that the claim of the petitioner is fallacious and baseless. Full stop. She submits that the aforesaid market has been running over private patta land since long, and by mistake, it was included in the NIT dated 1/6/2024, which was subsequently rectified in the subsequent NIT dated 26/5/2025. Full stop. It is submitted that section 107 and that reliance by the petitioner on section 107 to support his claim is misconceived, inasmuch as the concerned 50 number Tarakandi Gau Panchayat had issued necessary trade license to the concerned person. Full stop. She has in fact placed on record a copy of the trade license issued by the aforesaid Gau Panchayat. Full stop. The para supporting her submission, supporting the submission of the learned of the department, comma, Sri H. Ali, learned counsel for respondent number 8, has submitted that the market has been running for the last 18 years on a private patta land. Full stop. He has also submitted that the petitioner, that the respondent number 8 has been wrongly arrayed as a party respondent, inasmuch as it is the father and the uncle of the respondent number 8 who are the patta holders of the land in question, which is a private land. And those individuals, those entities have not been made party respondent. And on this count alone, the petition is defective and is liable to be dismissed. Full stop. He has also submitted that though wide notice dated 1/6/2024, the market was put to advertisement, comma, no settlement was made, which was rectified by the subsequent NIT dated 26/5/2025. Full stop. Para. The rival contentions have been duly considered. Full stop. Para. The basis, the primary basis of instituting the present claim is that the petitioner is an aspirant to aspirant for settlement of the market in question, which was advertised on 1/6/2024. It is, however, not in dispute that the aforesaid process, which was initiated by the NIT dated 1/6/2024, was not carried forward, and rather, wide the subsequent NIT dated 26/5/2025, the aforesaid market was excluded from the purview of any settlement. Full stop. The justification given by the department as well as by the private respondent is that the market is running on private patta land. Full stop. The aforesaid projection is a projection on facts which is not disputed. Full stop. Para. At this stage, comma, it would be required for this court to also consider. No, don't like this. Para. The scope of approaching a writ court is primarily to enforce primarily for enforcement of a right which is right of a litigant. Full stop. In the instant case, comma, the petitioner, by claiming to be an aspirant to participate in the settlement of a market cannot have an enforceable right to demand the process of settlement of such market. Full stop. The justification given by the respondent department as well as by the respondent number 8 appears to be relevant. Full stop. At this stage, this court may also deal with the submission with regard to section 107 of the Act of 1994. Full stop. The said provision is primarily to restrict any unauthorized markets within the jurisdiction of the Gaon Panchayat. Full stop. The same, however, cannot be a restriction to run a market over private patta land, which in this case is not in dispute. Full stop. This court has also taken note of the trade license issued by the concerned Gaon Panchayat in favor of the incumbents who are the patta holders. Full stop. As rightly pointed out by Sri Ali, the learned counsel, the patta holders have not even been made parties in this proceeding, and on that count also, the writ petition may be held to be defective. Full stop. But be that as it may, in view of the aforesaid discussion, this court is of the opinion that no case for interference is made out. Full stop. The writ petition is accordingly dismissed.
I have actually made him party because he is collecting the tools, but not as owner of the land, your lordship.
That is his tactic.
Omelette.
Okay.
Lordship, my senior dinner is on legs, lordship. It takes some, done his senior minister, so after some time.
Just after a while, just a month after 10-15 minutes, let him come. After a while. Yes.
When English counsel, Mr. P. Rahman is out of station, madam.
Is it? When can we have?
So, my lord, in this case, my lord, I have a prayer, my lord. The last, my lord, update in the, my lord, the scan copy, my lord, is 20 October 24, my lord. Kindly have, my lord, update on that scan copy, my lord.
Yes.
Because
Okay, we'll fix a date then. A prayer for adjournment has been made on behalf of Sri P. Rahman.
Yes, my lord. P. Rahman, I am Islam.
Huh?
I am Islam, my lord.
P. Rahman, who is stated to be out of station. P. Rahman, Learned Counsel for petitioner, who is out of station. Put some.
Latest scan copy may be called.
Sri so-and-so Learned additional PP has also informed this court that the scan copies of the records dates back to
it is, my lord, 25/10/24.
25/10/24. Full stop. Para. In view of the above, while this matter is adjourned on the prayer of the petitioner, registry is directed to obtain to have the scan copy requisitioned from the concerned learned court to scan up-to-date scan copies, huh?
My lord.
From the concerned learned court. Next, immediately. Full stop. List for consideration. When? On can we have it on 20? To
my lord.
20th of February?
My lord.
Are you okay, Mr. Islam?
Just a moment.
Friday? Or we can have it on 18th
except 20 alerts.
Then 18?
My lord.
18. 18 March.
My lord. 18 March.
Oh, 18 March.
18 March.
18 March.
মাইল
এইটো সোনকালে মাৰি দিব হেৰিক পঠাই দিব লাগিব ৰেজিষ্ট্ৰিক এইটো ৰেজিষ্ট্ৰিক পঠাই দিব লাগিব স্কেন কপি আনিব লাগিব 19 years.
Made bill. Well, may kindly pay with the last order, madam.
Yes.
We have received instructions that the petitioner passed away, my lord. So we have asked the son of the petitioner to supply the fresh documents, including next of kin certificate.
Yes, Mr. Khatonia?
Yes, I have seen that
Okay.
instruction, madam.
When can you? We've adjourned it for some time?
Yes, madam.
Okay. Heard 3 NJ Khatonia Learned Council for the petitioner. Full stop para. 3 I Botakur Learned Council appearing for the respond number 6 has submitted that as per information received, the petitioner has passed away and accordingly the family members have been directed to produce the necessary, the relevant documents, including the next of kin certificate to do the needful in terms of the order in question. Full stop. 3 Khatonia de Learned Council for the petitioner. He submits that he is aware of the aforesaid development. Para, in view of the same, matter is adjourned to be listed on the 2nd of March.
Obliged.
Also, kindly pay the order dated 1/12/2026. 1/12/2025.
Yes.
That Planet Standing County BTCA appearing for the 3 and 4 submitted the instruction in the matter of the awaited, therefore some accommodation may be granted. And the directed to this.
Yes. Yeah, for the BTC.
Yes, sir.
Yes, what is your instruction?
We will obtain your lordship. We are actually we are newly engaged on November, your lordship. On last year we had been engaged. So we will.
But 1/12, almost a month has expired. Okay, we'll grant some time. Oh, Hearts to NNB Chaudhary, Learned Council for the petitioners. Para, what is your name?
A Sharma.
3 A Sharma, you're a BTC Standing Council.
Yes, sir.
3 A Sharma, Learned Standing Council, BTC. Submits that since there is a change of the Standing Council, some time may be afforded to enable him to get the instructions. Para, in view of the above, matter is adjourned to be listed on 2022. Bistari. 20th of February. Get the instructions.
Lordship, as per Honorable Court's order dated 3rd of December, Lordship, we were supposed to make a verification of the documents submitted by the petitioner. Here I have received instruction, Lordship, some more time they have asked.
Okay. Three. B. Chaudhary Learned
SSA.
Standing Council SSA has submitted that though certain instructions were directed to be obtained in terms of the order dated 3/12/2025, some more time would be required. He accordingly prays for a little accommodation. Ms. B. Bhuyan, Senior Counsel for the petitioner, is present. Para. List on when?
Lordship, after 3 weeks.
We'll give a date. List on today's 29.
29.
We'll have it on 23rd.
Yes, ma'am.
Madam,
23rd of February,
Yes.
sir? Yes.
Monday.
Respond number 7.
7. In current, no? Or 7. People.
Item 24 submits.
Yes, madam.
Lordship, there is a delay, Lordship, in filing the review petition, Lordship.
Yes,
Delay of 218 days.
yes. What is your explanation?
Explanation, Lordship.
You were depressed.
Yes, Lordship.
Is there an explanation?
And then also council also took time to draft and
Which council?
I took time to file.
No, there was a council earlier.
No, earlier in this, we are there, the council, Lordship. And thereafter,
No, who appeared in the writ petition?
my junior, at that time I was out of station the
But
day.
was she on record?
Yes, Lordship.
She was not on record
She was
in the
not-
present petition.
No, writ petition, she was there. Now
In
she's
this-
on maternity leave. Otherwise, if Lordship, I was just searching for the cause list to show to the court that she was there along with me at that time.
So, but the grounds of delay, the petitioner got depressed after an order of this court, 218 days, that for filing of a review.
And thereafter.
Okay, we condone the delay, assume that we condone the delay. What are grounds of review?
Lordship,
What is distinguishable with in a principle of law as enunciated by the Supreme Court in Debabrata with your case? How do you overcome a decade?
yes.
Madam, you are abusing the process of the court.
Lordship,
You are abusing the process of the court.
no, Lordship.
You are.
I apologize for
Now,
that.
can you overcome the fact that a decade has passed since the death?
No.
Then
that
if you
too-
cannot overcome after Debabrata Tiwari, how do you
yes,
justify your claim?
Sweet, actually, he
That
was.
that is not see Debabrata Tiwari is very clear.
Yes.
We have
Lordship.
quoted
Yes,
Debabrata
Lordship.
Tiwari, both the aspects.
Yes.
Even if the delays are attributed to the department, then also it cannot be done if sufficient time has passed.
Yes, Lordship.
And you have taken 4 adjournments at the stage of condonation of delay. Notice issuing.
Actually, the day.
Madam, you have to pay cost. You have to pay cost.
Lordship,
You have to
because I'm doing it pro bono, Lordship.
So we do not know. We do not know. Is it recorded that you are doing pro bono? We do not know. You have to pay cost. This is an abuse of the court.
Otherwise, I'll withdraw it, Lordship. I'll withdraw
No,
the
you have to
petition.
pay cost. We cannot afford to have an adjournment for 5 times and matter withdrawn. Sorry. We'll pass necessary orders. You pay cost. Yes, dispose of.
Depot.
What had? What had to go to Rakuma? What's the part of to go to Nagar? Really, part of no. Really? Yes, Mr. Sharma. Other side, CGC. Yes,
I
CGC,
think Samrat Saha Roy is on.
SS Roy. Please try to have him.
Well, let's say pass out for the time.
Let us see for a while.
Yes, sir.
What about Mr. Nath? That matter, Mr. Mohanta's matter? Has he come? Okay, we'll wait for a while. Please call Mr. Mohanta. Yes, Mr. Roy, which matter is yours?
23 madam.
23.
Next item, madam.
Yes, yes.
Yes.
23.
Lordship. Lordship, may I please, Lordship? In this matter, Lordship, the petitioner before your Lordship, that against the impugned order dated 6/1/2025, 2015, against the order of the learned industrial tribunal, and that during the pendency of the the petitioner was dismissed from his service as he is a protected workman under the industrial dispute act. He's the general secretary of the trade union of the Bukazan Cement. He's a Bukazan Cement Corporation Employees Union
and he raised some demands before the respondent number 3, that is the, that is Lordship, respondent number 3, that is the management of the Bokazan Cement Factory. And during that, during his demands, that is which was registered as a reference case number 17 of 91, where the petitioner was represented in the demand, and as he is working as a GS, and in the meantime he was suspended, and thereafter he was dismissed, Lordship. So accordingly, the petitioner appealed his dismissal order. It was appealed before the industrial tribunal.
And let us read the award.
Lordship.
You're challenging an award of the tribunal.
Lordship.
Let us read the award. What was this? It was by way of a reference, section 10 reference.
Lordship.
What are the issues? What are the issues of the reference?
Lordship, mainly issue was that.
No, let us see the award. It will be reflected in the award. Award starts at which page?
Award starts at page number 69, Lordship.
69.
Lordship.
69, award.
Lordship.
Award is it is 6/1/15
15.
by Industrial Tribunal Guwahati.
Lordship.
No, this is not a reference. This is a miscase.
Miscase, Lordship.
You said it's a reference.
The reference was pending before the management of the appropriate government. Appropriate government, that was an Annexure 1, Lordship. Annexure 1 started.
Reference is not pending. Your application for reference may be pending.
May be pending, Lordship.
Actually, while the reference was pending, he was dismissed from service. So he filed section.
Reference before which court?
Before the tribunal.
Tribunal was in session of a reference.
Yes.
Which one? Page?
They have not annexed, my lord, but
reference was not annexed, but
Lordship will see
the page,
page
Annexure 1.
35.
35. Lordship.
35. Page 36 is the reference, my lord.
36. Oh. It was with regard to the legality of a strike. The reference was pending.
That's pending, but during pending or reference, my lord, he was dismissed from service. So he filed an application under section 33A for violation of condition of service under section 33.
Okay.
So that was the tribunal, we raised a preliminary objection with regard to the maintainability of the petition. So tribunal has passed order in their favor, but we moved the High Court pilot, then High Court passed order in our favor. Then the matter was remanded back to decide the fresh whether he's a protected workman or not. Ultimately, tribunal passed the final order saying that he is not a protected workman. I prepared a short list of this, Lordship will.
We'll hear him first then.
But I just
Okay.
for the reference file.
There was an earlier round in the High Court.
Yes, yes.
High Court remanded it.
Remanded it.
That round was at your institution.
Yes.
And your writ petition was allowed and the matter was remanded. On the remand by the impugned award of 6/1/15, it has been held that the workman is not a protected workman. So he'll not get the benefit.
Not the benefit of the protected workman. Because Lordship will see series of on the basis of two documents, my lord, Exhibit C and Exhibit D. That does not prove that he is a protected workman. Because earlier he gave a list of 36 workmen, my lord, to be a protected workman. And that is not as per 33(4) of the Industrial Dispute Act. So he has been asked to reduce it and give it a correct. Then he didn't do it. Then we approached the labor court. Then labor court instructed him. Then also he done. So He is not a protected worker.
And the earlier award, which was the subject matter of challenge in your writ petition, what were the basis on which he was held to be a protected workman?
That was the tribunal's order, madam.
That is it,
Learned
tribunal.
So because of annexure C and D, exhibit C and D, he was held to be a protect because he is general secretary. So the learned tribunal held that being a general secretary, he should be a protected worker.
Okay.
So that was not the law.
High Court had interfered and
High Court
remanded
interfered,
for a
but
fresh consideration.
set aside the tribunal's order and remanded the matter afresh.
Okay.
Then the award is passed. Now his case is that the order has been not passed on basis of merit, and the order of the High Court does not say that merit is decided. So the matter has not been decided on merit. That is his case, madam. But tribunal order, Lordship may see from page 66 onwards, tribunal has dealt with all the issues he has raised and passed the order, my lord, which is running into several pages, my lord. Ultimately, the finding of the tribunal starts from page 18, my lord, page 83, para 18, my lord. If your lordship sees my list of dates, I have narrated, my lord, the date of events.
After the remand, there is a finding of the tribunal.
Yes.
That after the remand, the petitioner workman did
Did
not
not
produce
produce
any
any
document to show that he is a protected workman. Is it a matter of fact?
Yes, it's a matter of fact.
If the remand was only on the point to make out a case that you are a protected workman, the duty was cast upon you, heavy duty was cast upon you, burden, and that burden does not appear to have been discharged.
In fact, that cross-examination, my lord, he admitted that, lordship, the record is not here, but I think the record is not here, but that.
Record assistant, no?
And lordship may see,
No? Record
lordship may see, after that, my lord. showing
Record
that-
not called for. We'll have the records, Mr. Tribunal's record is necessary. We'll have the records. Rule was issued, but somehow records have not been. Though this matter was admitted, filed, order dated 17/12/2021, it appears that the records of the learned tribunal have not been called for. Full stop. Since the challenge is with regard to an award dated 6/1/2015, passed by the learned Industrial Tribunal Guwahati, the records may be necessary. It may be necessary for perusal to peruse the records. Let the records be called for. Let this matter be listed for hearing immediately on receipt of the records. as the same pertains to the year 2016.
A date may be given, my lord, maybe after 4 weeks or 5 weeks, whatever.
List on, we give a date. List on, today is 29th, on third is a holiday. On
10th of March.
10th of March. 10th March, Tuesday.
But in. Well.
Yes. Deeply obliged.
May I please, Lordship? Lordship, in this case, lower court record has been received. And on last occasion, my lord, on appraisal of about the vernacular, my lord, the Honorable Court passed some order regarding translation, my lord. That has been submitted to the record, my lord, but without furnishing the copy, my lord.
Asani. Translated copy asani.
A bunch of document has been. Also, it would be fair if we get the copy, my lord.
You make photocopies. You make photocopies, both of it. So that's, we have translated it for you. Photocopy you have to do.
Because otherwise, my lord, on that occasion, my lord,
Okay,
only because of since.
In terms of the Hertz Free M. Mohanto Learned Counsel for the petitioner. Also Hertz Free as just Learned Counsel for the respondent number.
All the rest.
For the respondents, Para. Pursuant to the order dated 28/8/2025, the records of the trial, learned trial court have been translated. Full stop. The learned counsel for the parties have prayed for affording them copies of the translated versions. Full stop. Para. The learned counsel are permitted to take to make photocopies of the translated records. Full stop. For which should be facilitated by the court master. Full stop. List for hearing when? On 12th February.
Yes.
You make it today itself, both of you.
Yes.
You do go ahead, way to record the translated copy.
Records.
Yes, next. Yes, I think we have heard this.
Council will be appearing through video conferencing.
Yes, yes.
My lords, in item 25, my lords, I have taken instructions. My lord, we have already paid him about 6,43,000 plus 58,000. That, my lord, may kindly have the first order. When the impugned order was stayed, the stay was a conditional stay that we follow 17B. So in adherence to that, my lord, we have been paying him regularly from December 21 till date, and in total we have already paid him 6,43,000. This important fact was not brought to your lordship's notice on the last date by my learned friend. And in addition to this, we have also paid the gratuity amount. So, my lord, he already stands compensated. I mean, even
No,
if you see,
Mr. Kumar, you are not, you may not be correct in contending that. Compliance of 17B is not a compensation. It is not a damage. We are asking you a lump sum. Even if we
My lord-
agree with you on
my
the
lord, I
merits
have-
of the
I-
case,
yes,
the
my lord.
17B you need to do only to enable these workmen to sustain the litigation.
Yes, my lord. My lord,
It is
that,
you cannot equate this to be any kind of a compensation or a damage.
no, my lord, that was,
Our
my lord is
instruction.
absolutely
And
correct.
payment of
But
gratuity is a matter of right. Gratuity cannot be equated. We are only asking you about a payment of a lump sum. That, of course, we have not even taken the views of Mr. Day. We
My
are
lord,
asking that to bring the
my lord,
litigation to an
I
end
have,
because we thought that you had some case made out
yes,
tentatively. So we thought that if that course of recourse would have been available or we.
yes, my lord, I have taken instructions on that.
Yes.
17B was the initial order of 17B was
Yes,
a,
17B, please.
my
do
lord,
not-
it was
please do not-
17B.
Please do not bring in the payment made after 17B direction. You
Yes,
make an
my lord,
independent
my lord,
assessment.
as
how much.
on date, as
Yes.
on date, my lord,
Mm.
after hearing me on the last date, my lord,
Mm.
we have made it apparently clear that 17B is inapplicable. He is not a workman.
Mm.
So
Mm.
since 17B is inapplicable, the money which we have already given, we are not seeking any recovery. That money itself be treated as compensation.
No,
Or,
I forgot your name, Mr. Kumar.
yes, my lord.
Let us see, let us get to the initial order passed by this court.
My lord, we are actually dealing with public money. My lord is well aware of
No,
that.
understood,
That's
understood.
that's the
Everything
only
understood.
difficulty which we have, my lord.
Everything understood. Let us go to the order. First order, what is the order?
First order, my lord, is in August. I'll just say, my lord, just once. That order is August 21. Last para may be read, my lord. That is relevant.
See, the first order which you had passed on
Yes,
3/8/2020
3rd August 2020.
2020 had said that upon hearing, it is directed the imputed award passed by so shall remain state subject to fulfillment of the
Condition under
condition under
17B.
17B.
Yes,
Now, this order was it the subject matter of challenge?
no, we did not challenge it. We rather
So
complied with.
now you taking a plea that whatever we had paid cannot be construed to be a payment under 17B, perhaps it will not be able to be accepted by us. So, but
My lord,
leave aside these things. You are a public, you are dealing with public money, but still then, we need to strike a balance.
yes, my lord.
So,
My lord, we are in your lordship's hand. Whatever, because my lord, ultimately,
now, Mr. Kumar, it will not come as a concession from you, but we want to make it slightly transparent. We don't want to impose anything which is unreasonable on a public.
yes, my lord, that's the issue
So
which
we
have
wanted for on that line, we wanted you to have the necessary instructions. Can you get back to us tomorrow?
Sorry, my lord.
Can you get back tomorrow? Because this
My lord,
balance will not be.
my lord, I
Now
have
remember, we have
specific-
heard this matter substantially. In fact, it was
Yes,
only
my
on this aspect we are trying to have your instructions. Next
Very well, my
2
lord.
weeks, this court will not be here.
Tomorrow I can get back, my lord. That's not.
Tomorrow will, Mr. Day?
Tomorrow maybe at the top of the board, my lord, I can join. I
Yes,
can just say.
tomorrow. Tomorrow
Very
is a
well.
motion day. Immediately after the motion, we will let your colleague be there. Yes, make a mention.
Yes,
We'll
ma'am.
have you on board and tomorrow.
Very
Okay.
well.
Okay.
I'll take this.
Heard 3A Kumar, Learned Counsel for the petitioner who has appeared online. Also heard 3 LCD, Learned Counsel for the concerned workman. Para. So pursuant to the order dated 22/1/2026, Sri Kumar has obtained certain instructions. Full stop. He, however, has paid for some more time to have further instructions. Para. List again tomorrow.
Very well.
Okay.
I'm deeply obliged to this.
Yeah, I can 30? 35.
This is a case where we have challenged the award passed by the learning court, madam.
Record আছে? Rudely up.
Record has come.
You are challenging an award.
Award, madam. That is,
You are the management.
I am management. My friend is appearing for the workman.
Okay.
Madam, prior to this award, madam, another award was there. Where, madam, the issue was that the workman was initially appointed as grade 3 employee, madam. And he was, for a particular period of time, he was allowed to work as grade 2 and his salary was not given. So he raised an raised an issue, madam, then an award was passed by the Industrial Tribunal, madam.
Yes.
And that reference number was 17 of 2024, 2004. Madam, during the
How did the award end?
madam, award said that the difference of amount
Yes, has to be
has to
paid.
be
to him.
paid. But during the pendency of that
Yes.
proceeding, madam, certain misappropriation allegations brought against the workman, madam, and that was notice was issued, and the domestic inquiry was conducted, madam. When it was found that he is involved in misappropriation, madam, or
Yes.
alleged misappropriation, madam, he was dismissed from the. He was supposed to be dismissed from the service on 16/2/2006, madam.
If your lordship permits me, my lord, award dated 23/2018 is under silence before your lordship.
I mean, coming to
Only we are asking about the earlier award.
I'm coming to that.
Yes.
Then, madam, he was supposed to be dismissed from service. As because the case was pending, so, madam, petition under 33.
Which case was pending?
The 17 of 2004 award.
But that award was in favor of the workmen.
During the pendency of the litigation, madam, that proceeding. Reference, madam. That reference, madam.
Now, when was the earlier award passed in favor of the workmen? To give him the difference?
Because the issue.
When? What was the date?
Was, my lord. Seven 2004. 7/9/2004 notice was issued.
No.
No, madam,
award. The earlier award whereby the difference in pay was directed to be paid to the workmen.
It will be, and 13/10/2006, madam.
13/10/06.
06.
Then in this period, there was allegation of misappropriation. You held a domestic inquiry and he was to be dismissed from service.
Yes, madam.
Then did you
Then-
dismiss?
He was dismissed.
Dismissed.
But before that, my lord, the petition was filed under 33(2)(b, seeking permission, my lord, from the labor court, my lord, because the labor court proceeding was pending, my lord. On 16/2/2006, my lord, a decision was taken, but that he will be dismissed, my lord. The workman will be dismissed. But because the pendency of the reference case, my lord, the petition under 33(2)(b was filed, my lord, before the labor court, my lord, before the industrial tribunal. But I am placing a
33 2B, my lord. But that petition was filed, my lord, that was pending. In the meantime, my lord, the award, the order, the 17 of 2004 of reference case was disposed of, my lord. Holding that, my lord, as because it is a hospital, my lord. It is a hospital. He was an employee of a hospital, my lord, Raphael Hospital. And hospital does not come under the purview of industrial dispute. So there is no reference case will be addressed to. So this is dismissed. On the basis of that, my lord, the petition filed under 33 2B was also dismissed. And accordingly, that the tribunal held that whatever decision they take, we have nothing to do with this reference case. So the petitioner was terminated, dismissed from his service. Now, taking that termination matter, that dismissal matter, another reference was made, and that is before the court, before my lord, the award was passed, my lord. Now we have challenged that award, my lord. That is 3 of 2016, my lord.
Let's read the award, perhaps something. The fact should be clear. Where is the award?
Award is a page number 78.
78. Reference 3 of 16.
Yes, ma'am.
Award dated 23/18.
Yes, ma'am.
Please read.
Award, my lord. The government of Assam referred this case for adjudication after framing following issues while notification dated 12 February 2016. The schedule of issues are as follows, my lord. Whether the management of Tata Referral Hospital and Research Center Sabua is justified in dismissing their workmen Nabin and Borua with effect from 16 to 2006. Number 2, if not, whether the workman is entitled to reinstatement with full back wages and any other relief in lieu thereof. The case is registered on the basis of reference of the government of Assam, White reference case number 3 of 2016. Notices were issued to the management of Tata Referral Hospital and Research Center, Sabua, and also to the workman Nobin Borua, White order dated 3/3/2016 to file their written statement after appearing before this court. The workman Nobin Borua contested the case and filed his written statement through the Assam Sah Karmachari Sangha, Panitola Circle, Tinsukia, stating therein that
The workman Sri Navin Borua is a clerical grade 2 employee of Tata Referral Hospital and Research Center Sabua. He is a regular member of ACKS Panitola Circle. The workman was appointed as OPD clerk in the Referral Hospital Tata Tea Limited with effect from 1/6/1995. White appointment letter dated 28/5/1995, which is enclosed as Annexure 1 in his written statement. On 17/4/2000, the management posted him as store clerk in the hospital, but without giving him proper grade and pay, that is being store clerk. He was supposed to get pay scale of the grade 2 post as per industry-wise agreement with the union. Therefore, the workman through his union raised a dispute before the Assistant Labor Commissioner Dibrugarh. The conciliation was failed and the Assistant Labor
Mr.
Commissioner.
Mishra, we'll have some other day.
My lord,
Today it may not be possible, and this code is not available for 2 weeks.
after 2 weeks.
No, we can have it next week. It is not tagged with this bench, because within an hour it will not be able to be complete.
It may take some time.
Sometime.
It will take.
But 19 matter, we'll fix the next Tuesday. If it comes convenient to you.
Just a minute more.
Next Tuesday is on 3rd.
Third, I think my lord, it is really
Third
3rd of February, 3rd February.
February.
Next Tuesday, no? 5 Next Tuesday.
Next Tuesday, we complete it because this is a whole matter.
Or 5th February.
5th, okay.
5th February.
Okay.
5th February.
Oh. We'll try to complete Mr. Rashid's matter, small matter. And Mohantas matter, we perhaps will, let's see what not is there, let's see. Paucity of time will not permit the matter to be taken up. First of list for hearing on 5th. Very good. Yes. Yes, Mr. Nath, instructions.
Here, my lord, I have talked to them. There is no vacant.
It cannot be. After 15, after 10 years, how do you expect?
They've already, all have been filled up. So at this stage, my lord, it is difficult because 2 of the petitioners they have got.
That we have recorded.
Yes. So, my lord, a procedure was adopted and accordingly they were considered. We have, in our affidavit, we have said that some of the documents they have not given, that is why some of the petitioners, they were not considered. Otherwise, whoever has given, they were considered. At this stage, my lord, with this vague
But
allegation.
what about the apparent latent kind of a
But
consideration so far as the private respondents are concerned?
I have also asked them in the affidavit, there is no rebuttal to that because there is no statement. That is what I find. But that can be, Lordship may direct them to look into that aspect. If actually those documents were not there and there is some defect with them, then of course, they are also not responding here.
So, Mr. Nath, no, you cannot take a via media. Either we interfere, we do not interfere after a decade. But if we cannot leave it there to them for reconsideration, because affidavits, which Mr. Rashid has pointed out, those are not affidavits in the eyes of law.
Exactly.
Some are blank, some are not notarized, some are given after a date, long after the settlement is over.
No, that my lord, I have that in the affidavit we have said that after the last date, no application was received.
Not application, the affidavit.
That's true. That's true.
We have noted some dates. Cutoff date was 1/3/19. Affidavit is dated 18/7/19.
And some are.
So far as respondent number 10 is concerned, page 46.
And some
Page
are
49, 11/3/19.
That my lord, I leave it
You
to
may
because-
be correct in contending that this averments as such has not been made.
No, my lord.
So
nothing.
you may not be in a position to Deal,
Controvert.
controvert deal.
That's true. That's true.
What kind of a challenge is this?
That's true. That,
My
that is,
another
that-
submission, to Lordship, is this. Today, probably we are not getting, but in future, if we are chances coming, we may be allowed to apply is for law.
Future,
there will be a
future,
process.
Mr. Usid, can
There
there
will
be,
process, my lord.
can there be a restriction on your participation?
That may not be, my lord, but that's.
At the same time, can there be an order to give you allotment? Cannot be. At
No,
best, we can direct for a fair
no,
consideration.
Only we have to consider. I will not
Yes,
say I
that-
will be allowed.
That even without any observations,
As per law, my lord, you may have
every
application.
citizen's application,
You
if
have
he is
application as per
eligible,
law, my lord,
Along
that
with-
is bound to be considered.
Along with all other eligible, they will be definitely considered.
Okay, let us
Lord,
finish this off.
my lord.
Private respondents have not appeared,
Not again.
served.
Chap. Notice.
Which order?
We have taken a statement as per. procedure, as
No,
per
no,
order.
no, you are taking steps, will not do. Okay. The instant application under Article 226 of the Constitution of India has been filed with the following relief, page 13. Full stop. Para. 13, prayer put them. Yeah, para. As per the facts projected, comma, the petitioners, who are 8 in numbers, had participated in the allotment process of certain rooms under the Lanka Municipal Board, which was advertised on 26/2/2019. First of the rooms are in the Pioli Fukan Market, first within bracket first and second floor in the Lanka town. Full stop. The petitioners claim to have filed their applications with all relevant documents and fulfilling the criteria. Full stop. However, the settlement was not done with the petitioners and were done with the private respondents. Full stop. Para. I have heard Sri E. Rushid, learned counsel for the petitioners. I have also heard Sri D. Nath, learned senior advocate, appearing for the official respondents. Full stop. As regards the private respondents, comma, there is a detailed order by the learned Lazima Court dated 22/1/2026, whereby few of the private respondents have been served and few and there is no definite service report with respect to some of the private respondents. Full stop. However, considering the order which is proposed to be passed by this court, comma. The private respondents, however, have chosen not to appear and contest this proceeding. Full stop. Be that as it may. In view of the order proposed to be passed by this court, comma, the presence of the private respondents may not be necessary. Full stop. Sri Rashid, the learned counsel for the petitioners, has submitted that the petitioners had submitted their applications pursuant to the notice dated 26/2/2019 in time and by fulfilling all the requirements. Full stop. However, the cases of the petitioners were not considered in the proper perspective, and on the other hand, the settlement of the rooms were given to the private respondents illegally. Full stop. The learned counsel, he has also drawn the attention of this court to the documents obtained under the Right to Information Act and has attempted to demonstrate that the documents of the private respondents were not in order, more particularly the accompanying affidavits with the application for such allotment. Full stop. He accordingly submits that necessary interference be made by this court in the interest of justice. Per contra, Srinath, the learned state counsel, has submitted that though the incumbents who have been given the settlement have been made parties, no specific allegations of any nature पानी पानी खोज देता गरम पानी पीना है no have been made against them. Full stop. In this connection, comma, the Learned State Council has drawn the attention of this court to the averments made in the petition, more specifically those in paragraph 15, which reads as follows. Which reads the read averments read as follows. Page 11, paragraph 15. Full stop. He has submitted that since no specific averments were made in the petition, comma, no rebuttal could be made in the affidavit in opposition filed by the respondent number 4 on 18/11/2022. Full stop. He has, however, informed this court that out of the 8 numbers of petitioners, petitioners number 2 and 3 have already been allotted vitas, VITs, which is full stop. He has added that the petition number 2 has been allotted a vita in the second floor, whereas the petition number 3 has been allotted a vita in the first floor of the market in question. Full stop. He has submitted that out of the 8 numbers of petitioners, applications of few of the petitioners were not received and the others did not meet the requirement. Full stop. In any case, the settlement process was fairly done, in which the beneficiaries, in which the suitable persons were given the benefit of such settlement in a transparent process. Full stop. Para. Sri Sri Roshid, the learned counsel for the petitioners in his rejoinder has submitted that even that even if this court is not inclined to interfere with the settlement with the private respondents, comma, a direction may be issued for consideration of the cases of the petitioners as and when the process of such settlement of vitas is done in the future by the Lanka Municipal Board. Para. The relief prayed for in this petition have already been extracted above. Full stop. The same pertains to interference with the select list for allotment of the market rooms in the Pioli Fukan market under the Lanka Municipal Board. Full stop. It, however, transpires that the petition numbers 2 and 3 are also the beneficiaries of such allotment process. Full stop. So far as the allegation of illegalities regarding the settlement done with the private respondents are concerned, comma, a bold bold statement has been made in paragraph 15 of the petition, which have already been extracted above. Full stop. This court finds force in the contention advanced by the learned state counsel that in absence of any specific allegation, comma, it may not be possible to rebut the same. Full stop. This court has noted the submissions of the official respondents made in the affidavit in opposition dated 18/11/2022, whereby the process of allotment has been justified. Full stop. This court is of the view that in absence of any categorical averments, the specific and categorical averments with regard to the allegation of illegalities qua the settlement made with the private respondents, comma, there may not be a scope for interference with such allotment. More so when two amongst the petitioners are also the beneficiaries. Full stop. Para. In view of the above, comma, para. And this court has also noted that sufficient time has elapsed since the date of settlement, and interest of justice and equity may not require any interference at this stage, which will amount to unsettling settled position. Para. In view of the above, comma, this court is of the view that no case for interference is made out, and accordingly the writ petition is dismissed. Full stop. It is, however, needless to mention that in any future allotment process of vitas oblique market rooms, comma, the petitioner's case, if the petitioner, cases of the petitioners, comma, if the petitioners apply for the same, comma, their cases are to be considered fairly and in accordance with law. Yes, Mr. Monk.
Yeah.
City bus.
City bus. Well, there are two petitions, 32 and 33.
Which will take first?
Lordship will take up 33 first. That is the
7, 166,117. 6,117.
6,117.
Okay.
It was not 6,117. What happened, my lord? This association, Metropolitan Transport Association Guwahati. Under their management is a registered organization. Under their management.
Who's the petitioner?
Petitioner is the
Association.
Metropolitan Association of the city bus owners of the Greater Guwahati. For few decades continuously, city buses are being run in the routes of the Guwahati under the management of this association. And therefore, all the city bus owners are the members of this association. And this association has come against the impugned order. Now, these city buses were granted permits, these carriers permit for plying their buses in the specific routes. Lordship may see, we have given the names first in Annex 1, 153. That is the members of the association. That is the owners of the city buses. And this is the Annex 2 is the certificate from registration. Now, thereafter, Lordship may skip the.
What is the cause of action?
Cause of action is the authority,
The
Regional Transport Authority, Kamrup, has taken a decision. It is at page 80.
One.
7.
80.
80. This is the minutes of the RTA board meeting. What you've got it, Mal?
Yes, please.
8 April 2025, right in column top.
Yes.
All members present, Lordship has seen. They are the members of the participants. And RTA board decided we can skip over a few and then straightway come to page 83. Page 83. I am reading from page 83 top of Malan. This heading says left hand column, serial 2, designation of city bus route number 23 and 36 as green routes and renewal of stage carriers permit of diesel operated buses plying in Kamrup Metro. Now, from the top, the ACT Assam and the DTO of and Secretary RTA Kamrup Metro informed that as per resolution number 10 of the RTA board meeting held on 20/12/2024, the MTAG has submitted an affidavit seeking withdrawal of the Honorable Guwahati High Court case number so-and-so. This follows the decision to allow the remaining 46 buses out of the original 196 involved in the case to operate under the previous stage carriers permits. The DTO
and Secretary RTA Kamrup Metro further informed that approximately 169 diesel operated buses, including 19 of the 46 aforementioned buses, are currently plying on city bus route number 23 and 36. These routes have been designated as green routes as per RTA board resolution. Kindly note this, my lord. My lord, previous case, in the first paragraph, Lordship has seen, the reference was made to WPC 550.
What was that?
That was the authority removed 200 city buses from the roads arbitrarily and refused to let this permits, certain permits which was to be expired or some has expired, to renew that. Therefore, we approached this honorable court. This honorable court initially put a halt to that order. Subsequently, they had allowed us to continue there. All buses were taken back. We were plying all those buses. Therefore, the case was ultimately withdrawn. That was the case earlier. The order of decision again. Lordship may, for the time being, see the order. We have annexed. That reference is there. Page 113. It didn't do. Oh. My lord, at page 111, Lordship may see the operative part of the interim order passed in the earlier resolution. Paragraph 16. Having found that before taking action by the impugned notice dated 12/11/2023, which amounts to suspension of the permit, no prior opportunities have been provided to the stage carriers permit holders of those 200 numbers of buses. Prima facie, the same amounts to violation of the principles of natural justice. In such view of the matter, this court is of the considered view that the petitioner has made out a case of interim relief in the form of suspension of the notice dated so and so. Accordingly, it is ordered that till the returnable date, the operation of the notice dated so and so, whereby 200 numbers of city buses having valid permits have been withdrawn with effect from 1/1/2024 shall remain suspended. As a corollary, it is further observed that this interim order shall be in respect of those stage carriers permits which have valid the period beyond today, that is 7/2/2024. It is however observed that pendency of the petition shall not be barred for the state respondents to consider the modification of the permits of those 200 numbers of buses after hearing the permit holders strictly in accordance with the provisions of the Motor Vehicles Act 1988 and the rules framed thereunder. That was the order, and thereafter compromise was made because they would have withdrawn that notice and we were allowed to apply. Hence, the petition was withdrawn with liberty to come afresh if occasion arises. Next page at 115, that order was recorded on 1/5/2025. Last but one para, in view of the above petition.
Page
115. 115. একেটাই নহয় withdraw the petition. Interim order will Lordship will find a main petition, that is 117. 117 is the pass in the main WPC. Last but one para, in view of the order passed today in ISO and so permitting the respondents to withdraw, the present representation stands dismissed on withdrawal with liberty as paid for therein. That is the order. Now, here Thereafter, what happened? The authority took a decision as I was placing at page 83. They have already designated the route 23 and 36 as green routes. And what they now want to say is this. In this regard, paragraph 3 at page 83, in this regard, the RTA board resolved that the renewal of stage carriers permits for these buses shall be granted as a 6-month basis, similar to the process of diesel-oriented buses on other routes. However, the validity of permits for buses operating on routes number 23 and 36 must not extend beyond 31st December 2025. The DTO and Secretary RTA Kamrup Metro shall ensure strict compliance with this deadline. This decision was made to the detriment of the members of this petition. Therefore, we have come challenging this, that this decision is arbitrary, illegal, and without any basis of law. And notice was issued with notice to interim order. And thereafter we exchange affidavits. Meanwhile, the occasion arose to file the second writ petition.
7263.
Yes. Here, Lordship may, in this my petition, first petition itself, which your Lordship is taking up, kindly see the prayer. At page 28, it starts at 27. 27. Issue rule calling upon the respondents to so cause as to why a writ of mandamus should not be issued, directing the respondent authorities to recall or rescind, cancel, and or forbear from giving effect to the impugned resolution number 2 of RTA meeting dated 5/4/2025, and further to direct the respondents to renew the permits of the buses for the statutory period and to declare that the renewal of permits in route number 23 and 36 for a period of 6 months, at least at almost the same rate, prescribed for a 5 years permit is arbitrary, illegal, and liable to be interfered with. It is further prayed that this honorable court be pleased to direct the respondent authorities to allow the city buses of the petitioners to ply.
Now, what is the present stage, Mr. Monto?
Well, now they have asked us to withdraw the buses from the routes, not to ply there. And some of them whose permits were already expired, when they went for renewal,
It was declined.
they declined and they imposed certain conditions. Unless you agree to divert, we are not doing. So you give an undertaking. So on course they had to give some undertaking.
A divert means where would the new routes be?
No routes. in the
New routes were outskirts.
Outskirts of the city leading to the suburban areas. That is. And when this was pending, the second petition was filed because on the basis of this resolution, impugned here, they have started issuing notices to us. This is
Regarding?
kindly take up the second.
Notices for?
Notice for asking us that your routes have been mandatorily changed. And you will have to opt for other routes, give options. This notice, Lordship will find at page 87. Second petition.
87.
87. Similar notices were.
Of the second petition.
Second petition. individually notice was given, and we have annexed few copies of that. Same, similar. Here, Lordship will see to so and so, and then contract number so and so. Notice for mandatory rerouting of your stage carriers permit number so and so for the vehicle bearing registration number such and such as per provision of section 72 of the Motor Vehicles Act 1988. Lordship will kindly note this. This is the subject. With reference to the subject cited above and in compliance with the RTA Board Authority resolution dated 13/10/2025 issued under the purview of section 72 of the Motor Vehicles Act 1988, I am directed to inform you that as part of the Green City Bus Route Initiative, this is, they want to say, this is a scheme, so to say, an initiative to promote cleaner, safer, and more commuter-friendly urban transportation. Diesel-fueled city buses will be phased out from city bus routes number 23, Khanapara to Dharapur via Ganeshguri flyover, and route number 36, Bosistha Mandir to Dharapur via Palton Bazar, with effect from 1st January 2026. Accordingly, your aforementioned vehicle, which is currently plying on route number 23, shall mandatorily require to be rerouted in any one of the following routes of your choice as per the recommendations made in the joint inspection report submitted by the members of District Road Safety Committee, Kamrup, so and so. They have given these 10 routes here. And they have also shown the how many numbers will be available, slots will be available there, they have shown there. And then after this table, Lordship will find, therefore, you are instructed to appear before the office of the undersigned as on or before 22/12/2025, along with the original stage carrier's permit of your aforementioned vehicle and all relevant documents for mandatory route change, so that your vehicle could ply on one of the aforesaid routes of your choice with effect from 1/1/2026. Then, important note, the choice of routes will be allotted on first come first served basis, subject to slot availability. Any bus owner who fails to appear by the cutoff date, that is 22/12/2025, will be allotted a route randomly. Such owner shall be required to operate her bus on the randomly assigned routes with effect from 1/1/2026. This is for your kind information. This is being challenged here in the second route petition. And Honorable Court passed an order interim. That order is still being continued, where it says that liberty was granted to us. If in the meanwhile we want to go, we may go, but otherwise subject to our rights available in this petition. That was. Lordship, this order is dated the interim order 17/12/2025. Lordship, here, 15 minutes, paragraph 15. Considering the above, this court therefore till the next date observe and directs as hereunder. The members of the Petitioners Association who have not applied or migrated till date are given the liberty to apply for fresh permits on the alternative routes suggested by the respondent authorities. Such applications shall be without prejudice to the present proceedings. This court further observes and directs that the decision so taken to convert the route number 23 and route number 36 into green route is subject to the outcome of the writ petition, which this court shall consider on the next day. This court also observes and directs the respondent authorities that upon applications being filed by the members of the Petitioners Association to issue permits on the alternative route suggested by the respondents, subject to fulfilling the other requirements. While doing so, the respondent authority shall also duly consider the non-renewal of the permits would result in taking away the livelihood of the members of the Petitioners Association. This protection was granted. Thereafter, an inter-court appeal was also taken to the appellate court, saying that that's not the absolute protection to us. We need the stay of this. The Honorable Division Bench has ultimately was not inclined. The writ was appeal was withdrawn, but then the court has finally said
Yes,
I would like to place that order also.
that is okay.
And in that, because ultimately the court has said that all these points are available, you can argue, and this was dismissed on withdrawal. And also said that the order which was passed, it amounts to total protection of your rights, as has been agreed by the state government. The court has noted it. It amounts to total protection of your rights. Court has agreed to the submissions made by the government. Paragraph. Yeah, it will note that
I have a copy of the order.
That's okay.
It to put question. And that.
Now, what are your grounds
We
of challenge?
fully agree, Malad, that order, we fully agree with the submissions raised on behalf of the state regarding the non-maintainability of the present appeal, especially for the purposes of putting a blanket stay on the activation of the Regional Transport Authority, converting to the buses to green routes, permitting only the electric CNG operated buses to ply on the green route. That was thereafter said. Now, well, what happened? The facts are like this. Nasif has seen, they have in the RTA board has decided that these two routes are now
Green routes.
green route, declared as green routes initiative.
Which
And
is this 23 and 36? Which are these routes?
23 and 36.
Which factually, which one?
One is from
Khanapara to Dharapur via Ganeshguri,
Ganeshguri.
and one is Bosishto to Dharapur via Polton Bazar.
Polton Bazar.
23 is Khanapara.
And one
Khanapara to Dharapur
Dharapur
via Ju Road.
Via Ganeshguri.
Ju Road.
Ganeshguri.
Ganeshguri will not be decisive. Ganeshguri, other Palun Bazar also Ganeshguri.
Ju Road.
Ju Road.
And
And the other Vasista to
Bosishto to Dharapur via
via Paltan Bazar.
Polton Bazar.
Via Bora service.
Bazar.
Yes, Boras. Via Boras. These two arterial.
Via Bora service.
Via Boras service. These two arterial routes they want to reserve. And they say, therefore, your buses which were plying there will be ousted from that. You will have to migrate and we will not renew your permits. You will have to seek permit in some other routes, whether this is permission. Fact remains that we have a valid permit. The scheme of issuing a permit is road specific. Road specific permits are issued and the route is chosen by the petitioner himself. Route is chosen by the petitioner himself. That I want a permit on such and such route. And the authority, after considering it, if they find that yes, they should grant the permit on that particular route. So for the route is concerned, this is very specific, and the route, in that route only, that specified route only the bus can fly, in no other. Other conditions they may put, those are there. And if the term of the permit, tenure of the permit rather, tenure of the permit comes to an end, they can apply for renewal, and the renewals will be normally granted unless there is very specific some allegations or disqualifications of that particular bus owner.
No, those points will definitely be available to you, but ultimately you have to decide on the aspect of policy decision
Yes,
and whether the alternative arrangement given to you are viable, which do not cause immense difficulty or legal prejudice to you. Those are
Right.
the points which you have to consider.
right.
Whether your right to livelihood has been totally cut off, or whether you have been given avenue which is in the name, or whether in the avenue given in actuality in reality you can still survive in the
That is one part. Secondly, right of the petitioners, right of the permit holders, whether that right can be taken away by the RTA.
No,
board
this
in this way.
rights in a permit is a right upon an application made by you. It is
Yes.
for a particular period, which is
Yes,
renewable.
yes,
Now, you said that renewal is done almost as a routine unless there are exceptional circumstances. Renewal may be declined. Now, in view of a policy decision to convert these two routes into green routes, whether that policy decision is a valid policy, that you can argue.
yes.
We'll consider definitely. And whether that decision has infringed your right for carrying out business. Perhaps these are the 2 points we have
Two
to,
basic ones.
2 basic points.
So I'm grateful to your lordship. I will address first on these.
But look at the clock.
Oh. So
This
tomorrow,
court will not be there next 2 weeks.
tomorrow if can
We wanted to finish off these matters. You said there is urgency, they have also expressed urgency. Tomorrow is a motion day, and tomorrow there is likelihood of a reference also. Last day of the month.
Otherwise, my lordship may fix it, or lordship's convenience matter.
No, this court we don't make part of then this court, we'd have made that observation provided this court was available next week. Next 2 weeks we are not there. Till 13th, we don't want to hold back a matter.
True.
We can fix on Thursday next. You try your luck Thursday. Or Tuesday also.
I have some personal difficulty with the first part of the week.
Okay. On a date convenient to both of you.
Because my daughter is very good for me.
Mr. Nath, the green route means the green buses, which runs in battery.
Our electric and CNG, our decision is to put buses having electric and CNG mode. In fact, the option has been given to the petitioners also that you convert your buses to CNG.
Oh, that option is there.
Yes, it is given. They have in writing refused. We have annexed it.
Yes, we have shown the reasons
Yes.
why. Certain conditions.
Even
Practicable.
today also,
Which
if
cannot
they
be
said that,
implemented.
if they said that my bus is electric bus, I want to fly it. They can.
No, but still we have seen buses, normal buses being run on in these routes.
That's
How is it?
That's true, because
How is it being done?
well,
You have not implemented the
no,
decision.
it is being implemented, but because the buses, number of buses are not
Adequate.
adequate.
The green buses, so you're still allowing them to fly.
Secondly, the pendency of this case is also there.
Mr. Mohanta, your business as such, immediately there is no stop. You have been plying your buses.
No, in fact, out of 150, just in the one.
As a matter of fact, we have been noticing
Yes.
the earlier buses also being plied.
Some buses are plying.
Few.
And
they have not
Mr.
had
Nath has
very
said that the number of green buses are not adequate to the
Yes.
requirement. So therefore, they are allowing you to run,
But not all.
not all.
Few. Only 33, I'm told.
How many total?
67.
Out of 160, my
167 buses, 33 are being allowed to ply.
How was 33 chosen?
Other
Taking a-
rerouted their buses, already rerouted to other route. And they are not
The-
applying.
the others have gone. 16, only 16 have not applied. Out and 36 have applied, but they have not chosen the 10 routes which we have shown. They have chosen the routes outside the 10 we have the options given. And only 16 they have not come up till now. Some have taken NOC, they will not run their buses. That is their decision. Otherwise, out of 158, others have gone. 89 they have gone.
No, Mr. Mahunta, we have to balance our decision. Your rights vis-a-vis their policy, whether they have taken care of the existing business which you have been doing for the last so many years, whether there is an abrupt stop to that business, whether the avenue given to you is a reasonable avenue, which is viable also.
That will
Good.
definitely come, my lord. In the second leg of argument is this. First leg of argument is that.
But are you challenging the authority to make such a decision?
Exactly.
You're challenging.
Exactly. The RTA board has no authority to do this.
Okay.
There is specific laws for that. I will place it. They are conniving all these laws which are there. Why? What is the purpose of all these laws made? Rules are there.
So if that is your case ground, then we need to
Yes,
consider that.
I never dispute that policy cannot be taken, it cannot be implemented, but it has to be in accordance with law.
Yes.
By
And,
the
co-
appropriate-
and competence also.
competent authority, appropriate authority. RTA board suddenly decides something that will not give them the authority. Therefore, I have this submission. Thereafter, it will come here, having had the authority,
Competence.
under the law,
If
competency.
if you fail to overcome the
Yes.
first hurdle,
Yes, then,
they are still, we hold to be them to be competent.
yes,
Then you can
Once-
argue on the policy, whether the policy is reasonable or not.
Exactly. That will come.
Okay, well, we don't think we'll be able to complete. It will be hung. And you tell us a date.
Subject to if what my learned friend says, government advocate, if they allow our other buses as it is to meet, but they are now bent upon to see that all buses are ousted. This is as if it has touched their ego. This is what I am compelled to submit. This is.
Mr. Nath, if there is a requirement, let them apply till a decision is arrived at.
That's right.
See, this court did not pass any interim order. That has been upheld by the Honorable Division Bench. We are not going to again enter into that arena, whether interim order is necessary or not necessary. That has attained finality. But you can use your own discretion, allow them to function, apply till some such time.
Because their 100 buses have not come in as yet. That is also. Public convenience is also there.
But the decision.
How many buses do you intend to
100.
introduce?
100s are coming.
And how many?
No, already some are running and
How many
100s
are running?
But that exact figure, well, right now I don't have. But the
If-
buses are
You
coming.
can use your sound discretion if you think that the number of buses which you intend to introduce are not all the buses are not yet not started flying.
The
You can allow the petitioner.
decision.
They are using, it is for their benefit, public benefit. And we
Decision
will
is
take out
from-
our livelihood, nothing else.
Decision is to from 1st of January 2026.
Have you applied for giving allowing to run till the all the buses come?
No, they want us to go to alternate routes.
No, that we understand.
We
you
have not,
And have you applied for allowing you to run in the previous routes? You can allow
the existing routes.
existing routes.
These existing routes.
You can cite that all the buses have not come. Public demand is there. Buses are inadequate. We'll not make any observation, but you can in the meantime.
Lordship may observe, we can make it.
We do not-
Because matter is pending, they are allowing some of them to, and what consideration they are doing, they are to say. But we say that some 33 buses are now being flying.
Mr. Nath,
Madam.
advocacy factor, if it is not adequate, don't need to consider.
Still Lordship here is the matter of filing.
Well, there
And
is,
on
there
a
is
farm debt, Lordship can decide it. I am always waiting for the decision.
that aspect, Malad, in fact, Malad, that I don't have the instruction. My instruction is that from 1st of January, the decision is implemented.
No, this is
And-
just a
and
thought of the
this is-
court.
Well,
This
in
is
fact-
not
in fact,
coming as
while-
a, even as
Lordship,
an observation. We are
while-
just thinking that
While
via media, at least till the decision is arrived at, least is before us, we have to decide it other way.
possibly those two, three or few buses they are running, they have given some undertaking that whenever they will leave. That I don't know, Malad. Right now I don't know.
You
That is what, that is
you
what I'm
can adopt
asking.
a similar modality for others, you can give an undertaking.
The till
If it
hearing
is,
is
if it
complete,
is, if it is,
till
if it
hearing-
is there, Malad, I am just asking just verifying with my learned friend. That I don't have, Malad. If something is there, of course, Malad, they
You
can.
can explore that option. We can, in the meantime, choose a date of convenient to both of you. Mr. Mohanta has a difficulty next week.
Lordship,
We can have it on 10th, Mr. Mohanta,
10th.
10th Tuesday.
Tenth
Then Lordship, I
Tuesday.
have some, 11th.
11,
12th. 12th.
12.
Don't put it on motion day.
Yes,
Well,
motion day, let
Lord-
us not go for it.
Lordship is available on 16th, I guess.
From 13th, till 13th, we are not here. We are at
From
Itanagar.
16th, then my lord has heard the matter.
Yes.
It can be.
It's
can
not
be-
like that anyway.
Can be taken up on 16th or
it's
17th.
it's
Malad.
not,
Since Lordship has.
it's
at
not
least
attached to any bench.
We
Any
have
bench,
started the matter. Lordship,
roster bench will take up. We'll have it on 12th.
12.
12th. 12th, Mr. Mohanta.
Well, I have no difficulty, but then what I request your Lordship that this Lordship has given time, we have given time, can
Yes,
be heard on
my
16th
lord,
also.
pick
No,
up this
no
matter.
difficult, no 16th.
On 16, Malad, because 12th and 16 only one working day is there.
Okay, we'll try on 16th.
16.
Okay.
Deeply.
Provided the roster is with this bench.
I hope so. And meanwhile, Lordship may also say, they,
No, that will not say that. You can explore.
Yes,
Some-
Lordship.
They can apply.
Any observation at this stage?
No, we're
we
not
will
taking
not.
up those.
no, this is
Because after
understanding.
the division bench judge direction to give an expeditious hearing,
Yes.
passing any interim orders may not be
Lordship,
necessary.
Lordship.
Paucity of time,
Fine, my lord, they may.
necessity of time may not permit the matter to be taken up today. First of, as agreed to by the learned counsel for the parties. List on 16/2/2026.
Sixteen or 17? 17 is the hearing day, my lord.
Whenever you say,
17th. 17 to Lahara, 16 to Monday to 17th.
which date?
17th.
17th?
Yes.
Lord. 17.
Madam is very busy, it seems. Every day she has some problem.
In the month of February, actually, Lordship, I have.
Whatever
to-
date the court proposes,
No,
as a
Lordship, my
difficult-
son's exam, annual exams is coming there, so I have to manage.
then that's a very good reason.
Then 18th, my lord.
Son's exams and mother's exams. Parents' exams.
16 is okay because he has exam on 18th, so I'll be there on 17th, I'll be off.
16th, say, my lord, because motion day, miscellaneous matter.
Okay, 16th.
16th.
We'll try.
Lordship.
16th.
Second up.
Which month? Huh?
I know.
22. Which? Oh, CCC. Yes, yes. 22.
Right.
Well, Lordship, in this case, there are two respondents.
There are two?
Two respondents. One is the CGC and another is the union of the Union Bank.
They are represented otherwise.
Your Lordship, but since long, nobody is appearing.
We'll ask the CCC to appear.
Your Lordship.
15 matter. Oh my God. What are the
Your Lordship,
issue?
it's in covered matter. On the earlier occasion, I have submitted that this is regarding the outsourcing of the armed guard.
Okay. What is the, which order covers it?
So Lordship, on the earlier occasion, I have placed this judgment of the Honorable Supreme Court.
Yes.
I think it is in the records or.
2022 SCC online 1966.
Yes. Your
What is it?
Lordship. And the relevant paragraph is para number 5, which is the subject matter in this incident application.
Who are you?
I am Union Bank of India.
You're the bank.
Yes, your lordship.
22.
Yes, your lordship. Basically, one clause in the bipartite settlement, that is clause 3M.
Now, what do you, then you are challenging 3M.
31H and 31N.
Yes.
And in 31H, the learned tribunal below has interfered with my order, thereby have been stopped me from outsourcing the armed guard.
Okay.
That is the.
And what has the Honorable Supreme Court said?
Supreme Court has said that there is no bar. That is, the fact of the matter is that para number 5, your lordship.
Okay, perhaps this will cover, we'll do one thing.
Yes, sir.
We'll have it for disposal tomorrow.
Yes, your lordship.
Get us AGC, okay? Heard Sri M. Sharma, learned counsel for the petitioner. Also, however, there is no representation from the respondents. Full stop, para. In the interest of, Sri Sharma, the learned counsel has submitted that the issue involved is squarely covered by a judgment of the Honorable Supreme Court reported in 2022 SCC online SC 1966. Deputy General Manager, Union Bank of India versus General Secretary, Odisha Union Bank Employees Association.
Here is the Employees Association is of
Full
Guwahati.
stop. It is submitted that the appellant in the case before the Honorable Supreme Court is the same as the present petitioner. And the subject involved was an interpretation of clause 31H
31H.
and 31N.
Your lordship,
M.
31M is not here in
Or
the
31H of the bipartite settlement agreement dated 2/6/2005
5 as well as of 2010.
and 2010.
Yes, sir.
Full stop, para. Be it as it may, comma, in the since the respondents are not represented, comma, consideration of this matter is deferred till tomorrow. When it would be, when final orders will be passed, as this case is pending since the year 2015.
Your lordship, one small request, if allowed, your lordship, that I may not be available tomorrow.
Okay, no, but your colleague will be there.
Yes, she is.